My lord, at the hearing stage, my lord, the from long time it is pending. The petition is
Last
under
week,
threat.
more than 100 slips were taken.
My lord, I have been tried to, my lord, mention, but it is a hearing matter. That is why I am
Please
not
wait.
mentioned, my lord.
Please
Lordship,
wait.
kindly
My lord,
any-
may I be permitted?
Extension of interim order, my lord. For extension of interim.
Extension.
Lordship, may I private to mention a matter for motion matter?
No inclusion.
Motion matter.
Extension give. No motion.
Lordship,
Kindly.
Lordship, on contempt application, your Lordship had passed the last order.
Yes.
And,
Please come next week, Monday.
Lordship, kindly.
My lord,
My
may I
lord,
be
may I be
permitted
permitted to mention, my lord?
my lord, may I be
Hello.
permitted to mention the matter of Vishwajit Dev versus State of West Bengal for inclusion in the list, ma'am? My lord, because here the petitioner has not been awarded the certificate of the ICWA.
Nothing. All the list.
My lord, may I be
Your
permitted
Lordship,
to
may I be
mention one
permitted to
matter, my
mention
lord?
extension of interim order.
My lord, may I
I'm
be
praying
permitted
leave
to
to move
mention
one
one matter?
application, my lord. Extreme compelling
Expiring of-
My
circumstances,
lord,
my
may I
lord.
be permitted to mention one matter?
My lord, the matter
Your
remains is
Lordship.
petitioner being, my lord, she's a victim of raped, brutally attacked. Then, my lord, FIR has been registered. She was hospitalized, my lord. Then a letter has been forwarded to the SP to apprehend another further attack.
It's all right. What is the application? It's a writ petition.
Yes, my lord, police in action, unless the writ court intervene, my lord, today. My lord, I will be finished, my lord, because there was a second, because my lord, there is a second attack. Petitioner, the victim, again hospitalized for 5 or 6 days, my lord.
Now, who is attacking you?
My lord, he's a person, my lord, with the influential person. He is in custody. His associates, my lord.
File it in the department Monday. It will appear.
My lord,
Sunday.
may I be permitted
your
to
Lordship,
mention one
For
matter, my
interim
lord?
order, my lord, kind.
Come on Monday. Please
Your
come on
Lordship,
Monday.
may I
My
be
lord.
permitted
Grateful,
extension of interim order expiring on Tuesday, Your Lordship. May I kindly be permitted? Your Lordship.
Let him appear.
Transfer matter, Your Lordship, it has been transferred from the principal bench, Your Lordship. The transfer of a teacher, Your Lordship, of a Kuch Bihar, so it was filed in the principal bench. It's a new
Yes.
motion matter, Your Lordship.
Monday, please mention. Yes.
Your Lordship, may I be permitted extension of interim order
Extension,
expiring
please
on
pass
Tuesday?
on.
Your Lordship,
Extension, please pass on the slip.
grateful, grateful,
Item
grateful.
1.
Lordship, I represent the petitioner, my lord. Lordship, I represent the state. There is a correction.
My Lordship, my
Grateful. My lord, petitioner claim, my lord, CPF to GPF amount, my lord. Conversion. I'm handing over the correction order.
my Lordship, may
Petitioner was the teacher.
Yes, my lord.
Petitioner's husband expired বলছে
My lord, wife is come to the.
widow.
Yes, my lord.
Husband retired from service in 2004. Petitioner husband expired in 2006. Notification came into effect in 2014. Yeah, there is a similar order.
I cannot pay on for the state bank. I think I'm for the petitioner. Because I'm praying for Miller's restoration. It was dismissed for default, Miller.
Ground for restoration?
Because my application was belated by 50 direction to file opposition, my lord. Kindly. Because I've stated in para 3 of my application, can do, Millards. Kindly. Now, this is service matter, Millards.
Yes. When was it dismissed?
It was on 4th December 2023, Millards.
How the writ petition is maintainable here, my lord?
Writ petition is not maintainable is a different thing, but dismissal is 4th of December 2023. Right. When did you file the application? March 2024.
That's
Delay
it is
আছে।
I'm seeking for condemnation of blame.
After
After a
a-
year.
After a year?
Not after.
On 4th February 2020.
Not February.
Yes. 4th February.
December.
They have written 4th February.
No, the order is there. It's 4th of December 23.
That's
And-
4th of December, it was dismissed and.
and
filed on
March.
29th of February 2020.
All right, March
58
23.
days, that's all.
And what is the ground?
You know, at the relevant point of time, the mother of the advocate on record was not attend the chambers also.
ঠিক আছে, restored তো হয়ে যাবে। Now, what is the matter about?
This is a service matter. I am led by Mr. Surojit Samanto. He
Yes.
would be appearing in this matter. Mills kindly, the lordships, please to fix it in the next circuit. Mills, he will appear. Mills, I will communicate.
Restore করে দিন next subject. হ্যাঁ, দুটো অ্যাপ্লিকেশন আছে, ডিলে আছে। রেস্টোর করে, হ্যাঁ, রেস্টোর করে রিট পিটিশন হিয়ারিং ইন দি নেক্সট সার্কিট। Affidavit in opposition to the can.
Can, ma'am. There was
What
direction,
about the writ petition?
there was no direction because at that stage the matter was disputed.
তাই করে দিন। Let affidavit in opposition to the writ petition be filed within how soon?
2 weeks.
আচ্ছা 3 weeks করে দিন। Reply 2 weeks thereafter, liberty to mention for hearing before the available circuit bench. আচ্ছা, opposition to the can, file in court taken on record, দুটো আছে। Yes,
Grateful, Mills.
My lords, I appear for the petitioner.
Lordship, in item number 4, am I audible, my lord?
Very good. Mr. Mujumdar.
Yes.
My lord, kindly takes up this little letter already logged into court number 4, bail application is hearing.
right. Pass over for the time
Very
being.
In 5, Lordship, I am for the petition. The petitioner is praying for revising his family pension in terms of ROPA 2009.
9?
2009. Her husband used to be the teacher, he expired. Thereafter, expired in the year 2006, and the PPO was issued on 3rd April 2007. But it was given under the ROPA 1998, whereas ROPA 2009, it was given effect from 1st January 2006. So my
Failed, delay dismiss.
dismiss.
Obviously. You expected some other result, 2009 revision,
Lordship, may. Well,
6.
Lordship. Revision.
Item 6.
6, Lordship. This matter was supposed to appear on Monday, 28.
ঠিক তো, 28 April, Monday.
Item number 7, your lordship, I'm praying for a passover. Senior advocate Amlesh Rai is will appear in this matter. He's on his way, your lordship. Short passover, your lordship.
Are
He's
you the on record?
Okay, lordship.
What is the issue about?
Your lordship.
19 months ahead of the actual age of the
Are you there for the petitioner? Please continue. Who is your other side? উত্তরবঙ্গ কৃষি বিশ্ববিদ্যালয়, who appears? Where is your service? Where is he?
Your lordship, he's on his way. I'm praying for passover.
Oh, you are for Mr.
Yes.
Ray?
Yes, your
আচ্ছা
lordship.
ঠিক আছে, তাহলে pass over for the time.
Your lordship. Grateful.
Similarly, guest teacher. Yesterday, your lordship passed order. Done. Number 10. A guest. Did.
Disposed.
Every day.
Record your appearance.
Lordship.
My lord, I have not gone through the order, my lord. What-
I'm asking.
দেখি দি
Because I have
copy টা।
the instructions, my lord. So,
Yes, yes.
let
What is the
the-
instruction?
my lord, as per the instruction, my lord,
ROPA 19 beneficiary claims.
no, my lord, that is accepted and the same was sent to the higher authorities
yes,
for
yes.
approval.
Right, right.
The approval is pending on their end, my lord. The
Yes.
direction is given to the appropriate authority.
That has been given. Check the order.
আপনি order
Check
টা-
the order. Check the order.
That's all.
And see whether the appropriate authority has been directed. 12.
Yes, my lord.
Yes.
Your instruction may be written with the records. You can pass it on. 11. 11.
Lordship, I beg to appear on behalf of the petitioner, Lordship.
Yes.
Yes, Lordship, this is that matter in which a report was being called for from the
Matter
respondent.
learned additional advocate general will appear. Kindly make it a short pass over, Lordship.
আচ্ছা ঠিক আছে pass over. 12.
12 for the petition. The local library authority, chairman, local library authority issue an advertisement for recruitment of the post of librarian. This petition I apply for the said post in group D, ex-serviceman in category. Well, thereafter interview was held, he selected. Thereafter computer test was held, he selected. Thereafter, interview was held. But in the result was published. In the result, there is no category of exempted category serviceman. Kindly see page 33. There is a vacancy in advertisement. Kindly see page 33, my lord.
Yes. Ex-serviceman group D.
Unreserved one, ST1, ST1, OBC A1, EC1, and under reserved ex-serviceman. Kindly see, my lord, page 51.
Are you appearing?
Lordship, kindly allow me 1 day's accommodation. Yesterday they have received the brief. I
You
only
want time to take
yes,
instruction?
1 day accommodation, Lordship.
This week?
Yes,
or
not this-
Tuesday?
Monday or Tuesday. In detail, Lordship.
Tuesday?
Yes, Lordship.
লিস্টের নিচে লিখে দিন তো 29 তারিখ। Thirteen, Ipshita Ghosh. Where is Ipshita Ghosh? What is the matter about? Series of matters from 13 to
13 to
27.
7 short pass over. I am not at work.
Coming. Yes, what is it? Payment has not been made. All right, I have followed. Take your breath. Take your breath.
My lord.
Yes.
There are altogether 16 matters.
Yes.
All those matters are different amounts of their, and in some matters work is not complete.
Yes.
So I have asked them for the instruction. So they are preparing their instruction.
All right.
It will take some time.
All right.
We earn some accommodation.
Accommodation Tuesday?
My lord.
Tuesday, I'll keep it. Tuesday?
Tuesday.
Huh?
Better on Wednesday, my lord.
Wednesday?
If you like.
Wednesday. বুধবার লিস্টের নিচে বুধবার
Grateful.
from 13 থেকে
13 to my lord. This
27
27 and another one is there 23.
দেখছি
33.
and also 33.
Yes, my lord.
All right.
Altogether 16 matters.
Wednesday 30th. Take instruction.
My
One thing, madam, can you come to the answer?
the brief of the brief কোথায় দাদা
Stated that most of the work has been completed.
Very well. 28 call.
28.
I'm for the petitioner, madam.
Wednesday.
Lord, here is my affidavit of service.
Yes. What is it?
Key.
My lord, petitioner is completed his DLED course, my lord. He is paying for his A category, my lord, paying scale, my lord.
Who is your other side?
Lord, I serve the state, my lord.
28. Who is there? Check up the list.
My lord.
Madam, I appear for this.
My lord, petitioner has completed DLED course on last
So-
date of.
Show please.
My lord, page 19, my lord.
DLED last date of the examination.
My lord, give me a second.
Where is your schedule? March 16th, 2019. আমাদের usual order আছে দেখুন তো DLED course 16th March A category scale of pay. What is the instruction?
The DPSC Jalpaiguri appears to be the answering respondent.
Who appears?
DPSC, I don't know. Mr. Saurabh Ganguly usually appears.
Saurabh Ganguly. He is in the cricket field. Oh, he is local Saurabh Ganguly. Where is he?
Well, let it be a short passover, I will ask.
Call him.
Great.
Make a phone call, let him come.
Great.
In the meantime, find out.
Great.
29, I'm on behalf of the petition. Chief, the matter is in regarding the inaction of the police authority.
State. Yes.
Your Honor, your Lordship, the petitioner is the sole lady who has been, the home state office is situated in the, under the Mauja Drabgram. And the same has been acquired by, way of Patta from the government authorities. And he was, she,
Acquired by Patta.
by, RR Patta, refuge relief, department under government of West Bengal.
Acquired by the.
It was been gifted. Your
Gifted.
Lordship.
So it's
I
absolutely
apologize.
different thing you are saying.
I
Gifted.
apologize. It was
Right.
been gifted.
Yes.
After which, Lordship, the woman was living there. And the respondent herein, who is deemed to be a land mafias, they are by way of criminal act, they are trying
Did you
to.
serve the private respondents?
I have served the private
Show me the
respondent, but
service.
Your Honor,
এই দেখি স্যার এফিডেভিট অফ সার্ভিস সামনেই রয়েছে।
no, that's not.
Not yours.
No, I have said my law clerk is about to come. Actually, the item has not been received by the private
Then?
respondent yet.
Private. Private dispute.
Private
But-
Yes, I can understand. I
No,
understand.
not the remark.
Is there a report?
There is a criminal act, Your Honor. Several representation has been filed. What the respondents are doing, they are throwing stone, pelling stone upon the tin sheet roof of the petitioner.
So what will these authorities?
They are
do?
not only that, Your Honor, they are literally dragging the petitioner from their house and beating. Kindly see the representations which has been filed under the police authorities. And what I have learned, Your Honor, in respect of that report, yesterday the police authorities has called the petitioner. Kindly see the date of initiation of the FIR, Your Honor, if they has placed, Your Honor, before us. It has been made yesterday.
FIR,
Whenever they have got the complaint.
date of the occurrence is 5th of October 24. And the FIR is registered on 9th of February 25. Non-FIR. 11th of August 2018. Several FIRs are there.
Several FIRs
Started
are
from
there.
2018, Lordship.
24th of April 2025.
Yes,
further-
Your Honor, that is the point. Yesterday, he was been called by the police authorities and the FIR was been made. But my contention, why now? The representation has been made several times. After the getting of the requisites, now they has been acted upon by filing the representation. It should be done earlier also.
Should have been done earlier.
Earlier
yes.
also, Your Honor. That is the that has been arise, Your Honor.
Right.
And in respect of that, Your Honor, kindly see several not only that, Your Honor, medical has also been attached therein today.
What is the problem? Problem is with demarcation?
No, ma'am, not a
What is it?
demarcation, Your Honor. I am the sole owner of that said land. What he is doing that they are encroaching the surrounding land and now they have come upon me. I am living solely there. And what they are doing that they are trying to
What can the police do? Tell me. What
Yes, Your
will the police do?
they are
To
threatening.
what extent? You want the police posting to be there?
Actually,
If somebody threatens you on regular
threatens.
basis Will the police go over there every day?
Kindly initiate, at least the initiation shall be made seconds, then at least one inquiry has to be made in respect of the allegations that has to be done. That has been shown yesterday, which should be shown earlier.
None appears on behalf of the private respondents. Stop. There is no proof of service upon the private respondents. Stop. Let notice be served upon the non-appearing respondents. Stop. The police, the state respondents is directed to file a progress report with regard to the FIR number 264/2025. Dated 24th April 2025. Jalpaiguri NJP police station. ঠিক আছে? Released on first. First come back, let us see what progress report they brings.
Gratefully, Your Honor, grateful.
Item 20 for the petitioner, Milord, for the, it is pertaining to police inaction, Milord. Only to private respondent, it is showing that item backed, Milord. Service upon the state has been complete. Grievance is that, Milord, the petitioner is the wife of the private respondent, filed a complaint under DV Act, Domestic Violence Act. Order has been passed by the learned magistrate of 3,500 maintenance per month, Milord. But that has not been complied with by the private respondent. Being compelled, petitioner filed a execution case, Milord. Learned magistrate issued DW. It was not complied by the state authorities.
What is your grievance against
Now,
the
Milord,
state?
warrant is pending. They submitted one non-execution report praying for time, and it is still in that stage. Petitioner is suffering since 2022, Milord.
2020?
2. She is in very distress, and warrant is not being executed. That is the grievance, Milord.
May I, Lordship, this petition become infectious because yesterday night, this opposite party was arrested, Lordship. He will produce before the learned court today, Lordship. I don't have the instruction right now, but I have the
I am
photocopy of
adjourning it.
Lordship.
Monday.
Milord.
You,
I'm getting
not
instructions.
Monday. Not Monday. I'll keep it on Tuesday.
Milord.
In the meantime, you go and oppose the bail.
Milord, gratefully, Lord.
Tuesday. Listed niche Tuesday.
31, Milord, I am for the petitioner. Service is not complete, Milord.
All right. Next circuit?
Next circuit, Milord.
List in the next circuit as pre.
Gratefully, Lord.
Service in the meantime. 32, Bapi Sarkar? No. Next circuit, none for the petitioner. 34, 33 হয়ে গেছে তো।
Advocate, my lord, matter relating to CPF to GPF, my lord. I have corrected the order, my lord.
Who is the petitioner?
Petitioner is the
Teacher?
teacher.
দেখে নেবেন তো প্রদীপ।
Order class, yes.
Yes, next. State, who was there?
My lord.
All right. 35.
35, my lord, pass over, my lord. Mr. Jana is appearing.
Pass over? Pass over.
Lordship, 36, 37, 30, 39.
Next circuit.
No, same nature, service would be affected most probably today.
All right.
Make it not today.
Not today.
Monday. Yes,
39.
36 to 39.
36 to 39, not today.
Grateful, Lordship.
40. 39 is not today. 40.
Well, 40 to 45 will transfer matter, my lord. Here, my lord, only ground is, my lord, a petitioner distance ground, and as well as, my lord, petitioner is the surplus teacher, my lord, of the state school, my lord. And, my lord, all are, my lord, intra-district, intra, within the jurisdiction
Intra.
of Kujibihar. Intra.
That means it will be the council.
Yes, yes, DPS.
Which council?
Well, Kujibihar, my lord, Mr. Rai. Yeah, this. Transfer matter, my lord.
DPSC কুচবিহার সবগুলোতেই হ্যাঁ
এই যে
DPSC কুচবিহার will consider হ্যাঁ হ্যাঁ distance and surplus teacher
same
আছে usual order is there yes
40 to 45
40 to 45 One by one appearances for the state possibly will be required. Please put in your appearances. 46. 46.
I'm for the state, madam.
Madhusri Dotto.
I'm for the state.
None for the petitioner, next circuit.
I'm grateful, ma'am.
Petitioner for the SGT, I have let go Mr. Arjun Ram for
What the?
47.
What
For
the?
petitioner.
SGT actually.
SGDA. Petitioner?
I'm for the petition.
Yes, what is it? Please, please.
Lordship, the issue is that I think the service with respect to some of the respondents are yet to
Not
be
complete.
effected.
Next circuit.
No, Lordship, in this matter, senior counsel,
They have challenged the reason order.
in this matter, senior counsel Bilodal Bhattacharya will be appearing. So
Let
can
him
it be
appear.
placed on Monday, Lordship?
Service is not
Lord,
complete.
it will be affected by today, Lordship. It will be affected by today.
We have to offer instruction also, madam. They have challenged the reason order.
Where is the reason order?
Last 401, page 1. Second last page.
It is the third round of litigation, Lordship.
401. 401.
Oh, ADM. It's a detailed order, I see.
Lordship.
Reasoned order.
Permission for erection of building in connection with the application number is hereby revoked.
Appear করতে বলো।
Liberty is given to the learner of the petitioners to approach the Jila Parishad authority for building plan.
দিলাম তো SGT অর্জুন রাম অর্জুন দা
Is additional executive officer
It is with respect to a cancellation of a
building plan.
building plan, Lordship.
Yes, I can see that.
Lordship.
And the petitioners have been given liberty to approach the Jila Parishad.
Jela Parishad. After that, our request was turned down
By the Jila Parishad.
by the Jela Parishad. Yes.
Page 405 is the last order.
Recent order.
It says you are to approach the Jila Parishad. Where is the order of the Jila Parishad?
Lordship, kindly fix this matter on Monday, Lordship.
I'll place it in the next week. They will next circuit because they will take instruction in the meantime.
Lordship,
And this is the
let
recent
it be
order.
on let it be on Monday, Lordship. Mr. Bilodal Bhattacharya will appear if in that case,
Let us come with instruction.
let it be on Monday. Let Bilodal Bhattacharya appear.
Thing is, somebody's appearing will not change facts.
Lordship.
Neither will it change the
Lordship.
action of the court.
Lordship.
Today, whatever the order will be there, Monday the same order will be there.
I have been instructed, Lordship, being a junior Lordship to Mr. Bilodal Bhattacharya, please meet on Monday, Lordship.
The juniors should learn how to take responsibility. Otherwise, he will never learn. Right? Learn to take responsibility, and I can assure you the order that is being passed today will be passed on Monday. Let the junior not suffer from any complexity that only if the senior will come, the order will change.
Lordship,
It will not change. It will remain same for the junior and the senior. Right? Nothing to get nervous. Be strong enough. Same order will be passed on Monday if I pass it. The order.
বলছি তো না শুনলে দাঁড়াবে না ওরা তো কি করতে পারবো আমি সময় মতো অ্যাপিয়ার করবে না
Dated 4th of April 2025, passed by the additional district magistrate and additional executive officer of the Jalpaiguri Jila Parishad, Jalpaiguri, whereby the permission granted to the petitioner for whereby the building plan permission granted to the petitioner has been revoked, is impugned in the instant writ petition. Stop. The impugned order appears to be a detailed one. Stop. Validity of the same cannot be decided without exchange of affidavits. Stop. Learned advocate representing, who are you representing? The state respondents and the Shiliguri Jalpaiguri Development Authority seeks time to file affidavit in the matter. Stop. Let the affidavit in opposition be prepared and circulated by 4 weeks. Reply, if any, within a fortnight thereafter, liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. Let this order be communicated to the non-appearing respondent.
Can it be 2 weeks, Lordship?
What?
The affidavit of the opposition,
Sir, your building plan has been revoked.
Lordship. That is the
Have
main
you-
issue.
have you-
I'm suffering the interest as well from the bank authorities also.
And have you started construction?
I have already constructed 3-storied.
Three stories have been constructed.
3-storied.
Litigation.
What round of litigation? আচ্ছা টাইমটা কমিয়ে দিন তো টাইমটা কমিয়ে 3 weeks করে দিন 3 weeks 3 weeks 1 week 3-1 so the junior's prayer has been accepted.
Lordship, I think Mr. Bilodal Bhattacharya's junior is there.
I apologize, my lord. I have been for the petitioner, my lord. There were some technical glitches, my lord. I apologize for that, my
No
lord.
issues, order has been passed for filing opposition. It's a reasoned order and it cannot be taken up in the
But my
very
lord,
first day.
my lord, but there is complete biasness on the part of the authorities. The authorities have recorded statement which has not been made, my lord. Completely interpreted our submission on a different note altogether and has passed the order, my lord.
Right, so the other side has to be given some chance.
My lord,
isn't it?
definitely, my lord, definitely.
That is the reason the time to file the opposition has been reduced on the prayer of the junior counsel who is present here. He was very apprehensive that the senior is going to scold him. So tell senior Mr. Bhattacharya
My lord,
not
I
to get
shall.
angry and not to
I shall,
scold
my
the
lord.
junior.
And even, my lord,
Alright?
I am also apprehending that I will be also getting,
No,
I will
please
scold,
don't.
get scolded by
Tell
Mr.
Mr.
Bhattacharya.
Bhattacharya that the request of the court
My lord, I
cannot be,
shall,
the
my lord, I shall
executed order
convey, my
cannot
lord.
be set aside in one day. You
My
have to give time to the respondents to file opposition.
My lord, my
All
lord, I
right?
bow down, my lord.
Call the next matter.
My lord, may I make one indulgence, my lord?
I am for the petitioner. Not I am for the petitioner. Petitioner along with some other persons purchased a piece of land measuring about 1.66 acres.
My lord, I've obtained the instruction as asked by the honorable court, my lord.
Yes.
I have only a copy, my lord. Let me get it. Logically passes it over, actually.
My lord, may I have a liberty to file exception?
Are you aware what is there? You don't even know. Is it in your favor or against it? What is your prayer? Tell me.
My lord, I preferred RTI
Yes.
for certain informations regarding the registration and supply me the particulars of the deed. My lord, subsequently reply at page 16. Kindly see the reply. My lord, here I was directed to make an inspection with the prescribed fee. My lord, subsequently being satisfied and agreed with, I preferred appeal. My lord, again same reply was given that to make an inspection of the records.
Go. Why don't you go and inspect it?
My lord, kindly comes to the next page. Now, interestingly, I made an inspection.
Yes.
And my lord, from the inspection, my lord will get from page 21.
Yes.
No record is found.
Yes. That is the reason you were requested to inspect because they cannot pass on any
My lord, the
information.
responsibilities are deliberately suppressing the facts, my lord.
All right. What is your
That is the court ruling, that only one. Was asked, she was asked, the petitioner was asked and did not turn up.
did not turn up?
Turn up?
Page 21, the inspection report is there.
They have, the postal endorsement is, it is returned back.
What has returned?
The information, what they have.
My lord, inspection was made, no record found.
Can you see?
Page 21.
Where is your query?
Your query at page 16, section 6 of RTI.
This is what they have said.
We are only to supply the particulars about the registration and deed number, query number, etc. And nothing else, my lord. These
minute.
information was not
Page
supplied.
16. Where is your query?
I'm sorry, my lord. Page 14, my lord.
Ah. Whether any sale deed has been executed for such and such? What is the number of the date? What is the date? I will keep the matter next week. I will keep the matter next week. You see what is the direction. Please come.
Lord, exception if any, Lord.
Oh, the petitioner seeks certain information under the Right to Information Act, 2005. Stop. The District Sub-Registrar Jalpaiguri has forwarded an instruction to the learned additional government pleader on 7th April 2025, which mentions that the searching window is open to all and anybody can search the records by paying requisite fees at the record section. Stop. The petitioner is at liberty to avail the said opportunity. List the matter on 1st of May. Come back. I'm keeping it pending. Go and search and see what happens.
Lord, again, same thing, no account for you.
Let me see.
Lord, may I have a copy of the
May I
report?
get it
Yes.
photocopied and?
Photocopy and give it to him also. এই রিপোর্টটা ওনাকে ফেরত দিয়ে দিন, উনি একটা জেরক্স করে এখানে দিয়ে দেবেন আমাদেরকে। এটা কিন্তু আমাদের রেকর্ডে থাকবে।
Lord, led by Mr. Bhattacharya, he is appearing virtually.
Which one?
49.
Yes.
Lord, kindly see me, Lord, the order of this honorable court on 8 January 2025.
Yes.
No, every time you cannot do that. Will not let that happen.
What exactly is it? The status of the relationship between the landowner and the oil company and refinery or the distributory? What is the relief
Milord,
that you
what
are
happened,
claiming?
Milord, the petitioner, yes, the petitioner is a licensee under the Milord Oil Company. The petitioner was given license to run the petrol pump. Now, Milord, petitioner has to, Milord, every year, Milord, has to, Milord, renew the trade license. Now, Milord, I approached them, Milord, Panchayat Shomiti, Milord, because this trade license, Milord, is for dangerous trade. This can only be given by the Milord Panchayat Shomiti. Now, Milord Panchayat Shomiti, Milord, kept it pending. I came up before this honorable court. Kindly come to 78 of the writ petition.
Yes.
What was the order passed, Milord, ultimately, Milord, at page 80.
Yes.
Relevant portion. Thus, this opinion that the authority cannot sit tight over the application, the concerned block development officer and executive officer of Madarihat Panchayat Shomiti must immediately take steps with regard to the prayer of the petitioner for grant of trade license if the authority finds that the application is in order. This was consideration. Am I audible, Lord? Milord, this was sent for consideration. If the authority finds that the application is in order and the application has fulfilled the criteria
thereafter?
required for grant of such license, thereafter, Milord, kindly comes to, Milord, page 83. It starts from 82, but the operating portion at 80, Milord, they have checked my application, Milord, for license, Milord, citing, Milord, 3 reasons. Kindly, if your lordship, kindly see, Milord, 84, page 84. Land document of Sri Shivani Das Bhomik. My client is not Shivani Das Bhomik. Shivani Das Bhomik was the number 551, land measuring about 0.66 acres, Daba. Accordingly, land document Srimati Shivani Das Bhomik bearing Khotiar number such and such, classification such and such, measuring acre, classification hotel from Form 11 electronically generated trade license certificate of the year 2022, 23, 23, 24 and 24 issue dated 30th April 2022 obtained from Gram Panchayat and not from appropriate authority of Panchayat Samiti. Now, Milord, from 2022, Milord, I have been not only 2022, from 18 onwards, Milord, I have been regularly granted trade license. This is the first time they are taking all these objections. On questioning regarding the documents required for renewal of MSHSD license, selling license, she acknowledged that she is aware about the required documents. Peruse the documents carefully and ask the petitioner to produce the following documents for renewal of MSHSD's selling license, and as per guideline issued by the government of West Bengal, Department of Food and Supplies, Directorate of Consumer Foods, right, such and such, dated November 2nd November 2018, a valid trade license enlistment certificate issued by the municipality, corporation, panchayat body as applicable. No objection from landowner. Rent receipt, she failed to produce. No objection from landlord. Milord, I do not know the landlord because I am only a licensee under Bharat Petroleum. And rent receipt as sought for in para 4A, 4B and C, though she submitted 4A form electronically generated certificate, which is not issued in proper, not by proper competent authority. Further, it is to mention here that petrol pump is running without proper land document. Well, how do I give land document? I was never the owner of the land. As the character of the land is not converted to petrol pump and which violated the
What
provision of
is your
section 4.
status with regard to the land in question?
Exactly. I am a licensee, Milord. The Bharat Petroleum, there was a petrol pump. Bharat Petroleum Corporation Limited gave me license to run the pump. Kindly comes to page 3 of the writ petition. Page 3 of the writ petition. Paragraph 3. May I place these paragraphs, Milord?
Yes.
Kindly see paragraph 3 onwards. Your petitioner states that your petitioner is carrying business situated in district such and such, such and such. Then paragraph 4, your petitioner states that one Shivani Das Bhomik was the original owner of the said land. The said Shivani Das Bhomik entered into a lease agreement with Numaligarh Refinery Limited, being the lease number 12 June 2006, where in the Srimati Shivani Das Bhomik, being lessor, was allowed the said refinery to use the aforesaid land as a storage depot or a service station for the purpose of selling or otherwise dealing with or receiving or handling or distribution of petrol pump or any of its products for a period of 30 years commencing from 1st of January 2006 at a monthly premium. Then paragraph 5, your petitioner states that the said refinery assigned the lease in favor of Bharat Petroleum Corporation Limited by way of a deed of transfer and assignment dated 23rd August 2016, and thus Bharat Petroleum Corporation Limited become the lessee in respect of the aforesaid property. Your petitioner states that subsequent to such transfer by a memorandum of agreement dated 28th August 2018, the Bharat Petroleum Corporation Limited granted license in favor of your petitioner for carrying on the business of the same in the place and in the same name style. Milord, your petition, next Milord, paragraph 7, your petitioner states that licensee granted in favor of your petitioner by Bharat Petroleum Corporation Limited has been extended till 23rd June 2021 by another memorandum of agreement for a period of 5 years, and the same is still subsisting. This is my status. I was giving her only the license to run the pump. That's all. I was never the landowner. I cannot give land document. I cannot give conversion document. And for this reason, Milord, my trade license is not being renewed. Lordship knows, Milord, my Lord's judgment is also there for renewal of trade license. The only thing the authority will look into whether there is a conducting a valid license or not. Nothing else. For that, Milord, the Lordship's coordinate bench had called for a report on 8th of January 2025. What is the status, Milord? That was, Milord, due to be filed today.
Let me see the report.
My lord. No,
Who are you
report
for?
I'm for the state, my lord. The report,
Who's for the oil company?
my lord,
No,
they
she
are
wants to put
taking
this forward.
Where is
time
he?
repeatedly.
Who is taking time?
The refinery, my lord, the oil company, my lord, they are presenting the report because that report will ascertain that
This
we
is
are
the
no
third
one.
adjournment being
Because
taken
the
either by
agreement,
the
the
state
initial
or
agreement, the lease agreement was between the
third adjournment.
landlady and the refinery. Refinery
Let me
gave
hear
it.
the refinery. Where is Mr. Ghosh?
That agreement is required, my lord.
Not here today.
Not here today.
They are not bringing the
Milord,
agreement.
Where is
this is the
missing?
third adjournment.
Where is missing? She is also not present. How will the matter proceed without in the absence?
I will call him.
Call him.
I'll call Mr. Ghosh. He'll be
I'm
here.
passing it over.
Yeah. Kindly pass it over.
All right.
Call him, he will be here.
Do you have a report with you?
My lord is
No, my
passing
lord,
it
they are
over.
not giving the report. The main issue revolves around that lease agreement.
I can
Because the
understand.
landlady says that they have no, there is no clause of sublease. So how the refinery gave lease to the BPCL and how BPCL gave the lease to the petitioner?
I can understand
That can
it,
be
My lord,
but
ascertained
then
my
by the
business
lease
is
copy.
closed, my lord, from
uh,
2023.
That's
My
why the
business
last-
is closed.
till the oil company comes, it will be difficult.
Yes, Lordship, kindly pass.
I'm passing it over.
Yes, Lordship.
Please wait.
My lord.
Yes,
Very good.
51.
For the state, Lordship. But the affidavit of service?
Yes. Yes, what is it?
Actually, my lord, this is a case for police inaction.
Yes.
We have lost, there, some nuisance was there. We have lost complaints, several complaints before the concerned police station, even before the commissioner of police. But as the private respondents are very much influential, so that
Shahu Bhavan.
Shahu Bhavan.
Anybody appearing? Did you serve?
The outset is not maintainable, my lord. It has alternate remedies before the.
1 minute, 1 minute, 1 minute.
No, no alternative.
Noise complaint, Lord.
Noise pollution.
Noise pollution.
Lord, will probably find.
Did you approach the pollution board?
No, my lord.
Why? You are alleging noise pollution and you're not approaching them. What will the police do?
I have lost complaint to refrain
Where
them.
is the complaint?
Lord, may I place a copy of my instruction?
Please do. Where is your
Page number 11,
complaint?
my lord.
Page number 11. Prayer to
বলছি
do.
আলগা অপারেশনের ডিসমিস হয়েছে
11, 13.
Hmm. You have lodged complaint only before the police. You have not lodged complaint before the, where is this located? Within the panchayat, within the
Siliguri
municipality?
Municipal Corporation Lordship.
Corporation. So for the purpose of using a building for this purpose, a permission is required to be taken. You have not made them parties.
No, my lord.
Then why?
I may be permitted to add them party, my lord.
Assuming you are granted leave to add them as party, but no complaint has been made before
My
them.
lord.
So what will the purpose be served? No purpose will be served.
The complaint was treated as DD.
Hmm.
Registered.
And then?
PO was visited, my lord, inquiry was conducted.
And 107 CRPC prosecuted.
107 CR.
107 is maintaining peace. He
Yes,
says
Lordship.
that somebody
that is
is
the,
running a marriage hall from there and
Then
every
Lordship,
there is.
they will obviously they might be get the permission from the Siliguri Municipal Corporation because
So
it
that
is
has
under
to
the
be seen.
So they
Why
should
will the police not seeing it? Whether the business is being run without in terms of any permission being granted, it is absolute nuisance over there. The police ought to have taken steps under the provision of nuisance.
Lordship, all the sanctions and everything was given by the municipality Lordship. And
Why you did not take any initiative to contact the concerned authority? Whether they are
Please
Lordship,
come.
they did not make any pair before any concerned authority.
The petitioner alleges that Shahu Bhavan, which is adjacent to the residence of the petitioner, is being used for marriage purpose and for purpose of conducting other ceremonies, because of which there is continuous nuisance, noise pollution, and other illegal activities going on in and around the said Shahu Bhavan. Stop. A complaint was lodged before the police. Stop. Allegation is that no steps have been taken by the police till date. Paragraph. The Learned Advocate representing the state respondents has obtained instruction from the officer in charge, Khalpara Top, under the Siliguri police station, signed on 13th 9th of December 2024. Wherefrom it appears that the officer in charge visited the Shahu Bhavan and informed the president and secretary of the said Bhavan to maintain proper management in respect of waste of food and garbage, and also to obey the regulations of sound. Stop. Paragraph. The complaint was of the petitioner was treated as non-FIR. Stop. Paragraph. It appears that the petitioner ought to have lodged complaint before other authorities, including the West Bengal Pollution Control Board, the Siliguri Municipal Corporation, etc. Stop. The police also ought to have treated the matter in a better way. Stop. By only making a request to the offender to maintain proper management is not a solution to the problem which the petitioner is facing day in and out. Because of regular festivals and ceremonies being held at the next door. Stop. Paragraph. In view of the above, the instant writ petition is disposed of, granting leave to the petitioner to approach the competent authorities, highlighting his grievances. Stop. In the event such representation is made, the competent authority shall ensure that there is no nuisance caused at the subject premises and the peace and tranquility of the area is not disturbed in any manner whatsoever. Stop. The police shall ensure that ensure that there is no breach of peace in the locale. Writ petition stands disposed of. Service is taken on record. None for the private respondents.
Milords, I appear for the petitioner. Milords, here, Milords, an affidavit direction was there on 6th March.
I should be seeking an extension to file the affidavit. I have the instruction in my hand.
Milords, may I just submit one thing? In this case, I'm not disputing the facts, and this case is squarely covered by division bench as well as your lordship's decision. There's a GST case. Kindly post it for hearing, Milords, then next week. Any day, I'm ready with it. I don't need to file it. He's filing it. He has the instruction.
I have the instruction.
Instruction will not do.
They can file it in 1 or 2 days. I'm not disputing any allegation.
The tax invoice as well as e-way.
Whatever allegations they have alleged, I'm not
Of the
disputing.
learned advocate representing the state respondents, time to file the affidavit in opposition is extended till
2 weeks.
8th of May. Reply, if any, within a week thereafter. List in the next available circuit.
I'm grateful.
Grateful.
Short password. Affidavit is ready. Affidavit is ready. Lordship, short password. Short password. Lordship.
Affidavit is ready. Copy served.
No, your lordship, copy has
Just,
not been.
Coming.
Coming.
And then pass over.
Milord, in item number 54, Milord, I am appearing for the petitioner. Milord,
OP number 8 and 9.
Milord, am I audible to your lordship, Milord?
Very much audible.
Okay, Milord, now kindly see, Milord, the last order dated March 11, 2025. There, Milord, the last but one, Milord, the state on that date, my lord, filed a report. And direction was passed upon me, my lord, for filing exception, if any. Now, my lord, after perusal of the report submitted by the state, my lord, kindly take up that report for a minute. My lord, kindly take up, because may I take 1 minute, my lord, to just highlight the facts. My lord, the respondent number wife is respondent number 9 is my wife, and my lord, the respondent number 8 is the father-in-law. He is the upapradhan of a concerned panchayat. Now, my lord, my case is that there is a serious matrimonial dispute in between me and my wife. As a result, my wife has already approached against me under the Domestic Violence Act. Now, I have showed some document to the police stating that while my wife was admitted to hospital for the birth of the child, and while, my lord, she was during her pregnancy before the pathological center, her father, my lord, showed her as a, my lord, employee under the 100 days work, and, my lord, raised bill, and, my lord, obtained payment, although she was at that time staying with me, that is near about 100 kilometers away. Now, police came with a report. Kindly, my lord, take up the report. What the police says. My lord, third paragraph, my lord, I am reading for your lordship. Third paragraph from the bottom, third paragraph, third line. The executive assistant stated that he will conduct an inquiry regarding her work status during the alleged period and provide a response accordingly. Based on his finding, appropriate legal action will be taken by us as per law. So, the police has simply shifted the responsibility upon the shoulder of the executive officer of the panchayat. No finding has been given. So, my lord, we are helpless to file any affidavit in reply. My lord, kindly state them, my lord, to conduct an inquiry and submit a report in the form of an affidavit so that we can file our reply.
What is your allegation and what is the relief that you have claimed in the writ petition?
Sir, only thing allegation is while my wife was admitted in hospital at a distant place which is near about 100 kilometers away for the purpose of giving birth to her child, my lord, she was shown as a worker under the 100 days, my lord, 100 দিনের কাজ, that is 100 days work in a scheme under the panchayat. And while she was, my lord, appearing before the pathological centers, my lord, for the purpose of giving the test samples, she was again shown that she is working under the 100
No,
days
what
working.
is the relief? What is the relief that you
My
are
lord, the
seeking?
police has to register a FIR against the father-in-law who is the concerned upapradhan of the panchayat. Kindly see, and my lord, this is a case of fraud, specific case of fraud under section 420, my lord. They have
Why
to, my
are
lord,
you before the writ court? Why not before the learned court below?
my lord, kindly police, my lord, the panchayat, the records are lying with the panchayat. He is the upapradhan of the concerned panchayat. That is why, my lord, police is giving him shelter. They are not coming with the proper report.
So you want documents to be created?
No, not
relying
created.
on
The
which
document
you
I
will
have
proceed
already
with your case of
annexed
fraud.
with the writ petition. My lord, I have already annexed with the writ petition. They are not giving reply. Kindly appreciate, it's a specific case, my lord, where the upapradhan of the panchayat, although he is my father-in-law, I am admitting, my lord, that matrimonial relationship is very much sour, but he has abused his office. He has abused his office. My lord, some administrative steps has to be taken against him. It's a case, my lord, which has come up before your lordship, my lord, for abusing the office of the upapradhan of a concerned panchayat. He has raised fake bills, my lord.
I am the wife of the petitioner and
Who is for the Pradhan? Are you representing your father also?
father also.
Yes. The allegation is that you have
My lord, so far my
produced
instruction
documents.
goes, there is a matrimonial dispute.
Let the dispute remain. Tell me, what about the 100 days work?
I have performed. I have performed.
Yes.
Give me the dates.
My lord, dates they have. Dates they actually, my lord, I have performed my duties. And
Yes, give me the dates where you perform duties.
The daily wages sheet is lying with the office of the
Yes.
You are the
No, madam.
Upapradhan.
No, madam. Upapradhan cannot personally take that from the office. I it can be collected.
Give me the dates. And when did you give birth to your child?
Child is it about, my lord?
28th of November 2019, the child was born.
Born.
Right?
My lord.
And when was the work performed?
Work was performed in the, my lord, give me 1 day accommodation, I can take proper instruction.
Any instruction? Yes. But did she perform any work during the period when she was? Please. That is different. That is different. The parties will proceed.
No, my lord,
with
for the reason of family, that is the genesis of this case, my lord. I have been deserted. I am staying at my paternal house. I have lodged a complaint.
You are the father and you are the daughter over here.
My lord.
Right?
My lord.
And she
9 is the daughter. The daughter was deserted by the petitioner. And since long she is residing at her father's house.
In case number 94, lordship, the complaint has been lodged by the advocate, lordship, not the petitioner, lordship.
The petitioner alleges fraud against his father-in-law, the respondent number 8, who is the
My lord, one indulgence, may I seek?
Pradhan
My lord,
of the Banarhat 1 Gram Panchayat.
one indulgence, may I seek? So for the complaint, impugned complaint is concerned, that was lodged by one advocate. Petitioner himself.
No, she made the submission. Why are you repeating?
No, my lord, actually.
I have heard it. The specific allegation is that the respondent number 8, who is the father of the respondent number 9, has managed to squeeze out money from the state authority by using the job card in favor of his wife, mentioning the period during which she gave birth to her child. Stop. Paragraph from the report of the inspector in charge, Banarhat Police Station, dated 18th of February 2025, it appears that an inquiry was conducted in response to the complaint lodged by the petitioner, and a job card in favor of the respondent number 5 was confirmed. Stop. The report of the police mentions that further inquiry is to be conducted by the executive assistant of the Panchayat with regard to the work performed by the private respondent during the period when she gave birth to her child. Stop paragraph. The police is directed to conduct inquiry and file a report before this court on 1st May 2025, specifically mentioning the dates when the respondent number 9 performed her work in the months of October, November, and December 2019. List on first.
My lord, can you see the page number 34 of the application? The dates were already mentioned in the job card.
34?
34. P8. Annexure P8. I gave birth on 6th January 2020.
Requested period of employment,
My lord.
period and work on which
Job card.
employment offered. March.
How many days I have worked, that has been also been mentioned.
Date of birth.
And I gave birth in the month of January 2020. I attained my duties on 3rd March 2020.
Date of birth.
Lapse of 2 months.
28 November
You gave
2019.
birth on?
6th January 2020.
No.
No, the date is mentioned 28th of
No.
November 2019.
Yes, yes, my lord. 28th of November. That is at annexure P4 at page
Date
15.
of birth of the child is also different. How can that be?
28 November 2019. And my lord, in the month of November, it has been shown that she has
28th November 2019. Now, my lord, can you
Yes.
see when my performance was done?
Yes.
And here, my lord, from 31st December 2019, she has been shown working.
2019, you went to work.
My lord, because that was normal delivery. I have to survive.
And
I
that,
have to survive.
my lord, she
Because I have
was
been
staying in
deserted
the
by my husband,
hospital.
as well as the
She
petitioner.
had attended the pathological centers. Everything I have given. My lord, let
Listen,
the police file.
from the
file the
document
report.
that you have annexed to the writ petition, page 34, the period of employment is 31st of December 2019. 1 month before the child was born. Then where is the difficulty? With normal delivery?
She was, at that time, she was with me. And, my lord, that apart, I have also given, my lord, the medical prescriptions. My lord, kindly see, just for, my lord, example, kindly come to page 85. There, my lord, she attend 85. 85. See, 85.
Yes.
My lord, here, my lord, it's a, my lord, she attended pathological center, my lord, Neotia Gateway Health Care Center, Siliguri. And, my lord, the date of collection is, my lord, 11th of December 2021. My lord, these dates, my lord, the police should verify that I have given several documents that these dates she has attended the pathological center at Siliguri, and she was shown that she is working for under the under her job card.
She, the petitioner alleges fraud, बोलना. ठीक.
Page number, page number.
To hard child.
From the report of the respective child on her case, dated by 2 February 2025, it appeared that an inquiry was conducted in response to the complaint lodged by the petitioner, and the job card in favor of the respondent of the file was confirmed. The report of the police mentions that.
ওইখানটা কেটে দিন, কেটে দিন। এরপর লিখুন, from the documents annexed to the writ petition, it appears that the respondent number 9 was provided work on 31st of December 2019, and she worked till 15th of January 2020. Stop. The petitioner has averred in the writ petition that the child was born on 28th of November 2019. Stop. The private respondent had a normal delivery. Stop. The learned advocate representing the private respondent submits upon instruction that she has been deserted by the petitioner, and for the purpose of survival, she is required to work. Stop. Paragraph. Upon hearing the parties, it appears that there is a matrimonial dispute pending in between them. Stop. The petitioner has several allegations against his father-in-law and his wife. Stop. it will be open for the petitioner to approach the competent forum for remedy. Stop. The police or the panchayat authority will not be the appropriate body to provide any relief in the instant case. The writ petition fails and is hereby dismissed.
I'm good.
I'll finish the list and come. Prior to the hearing, prior to the hearing. 55. Let me see, let me see.
Lordship, matter is very urgent one. These petitioners, they are the unfortunate pattern.
Tuesday. আচ্ছা ঠিক আছে, affidavit in reply
Lordship,
filed in court is taken on
since
record.
30th January, I have been ousted from my own house.
ঠিক আছে, reply taken on record, list on Tuesday. আজকে দিল। replyটা জমা করে দিন। You filed the reply today?
Yes, Lord. Yes.
Tuesday.
Lordship, in that case, one oral direction may be given to the petitioners if I will enter into my own house that my daughter-in-law will not make any harassment or restriction. Since 30th
Who
January,
is appearing for the daughter?
he is appearing. Since 30th January, I have been
Why?
ousted.
Not for the state.
I'm for the state lordship.
Oh, you are for the state. তাহলে opposition টা private respondent দিয়েছে।
I have been ousted from my own house.
Who
I'm
are
the
you?
senior citizen.
আচ্ছা।
Then one direction may be, oral direction may be given. I should not be registered to enter into my own house. As because the medical treatment is highly required.
Tuesday. 56.
56.
Lordship, I am for the petitioner. Lordship, this is the second round of litigation. Lordship, page number 53 is the last order.
Who is the other side?
I'm for the municipal.
State, municipality.
Yes, ma'am.
Lordship, they were directed to file
Directed to file?
report.
Report.
Yes, Lordship.
Where?
Where is the order?
No, reported to direction, but anyway,
Lordship.
I have my instructions. My lord.
This is the second round of litigation, my lord. On the earlier occasion, my lord directed the municipality to send all the documents related to the recruitment process of the petitioner.
Lordship,
to the
till
TL
today, there is
Directorate
no.
of local bodies, my lord. Thereafter, my lord, till date, my lord, we haven't received the report from the directorate of local bodies, my lord.
Who are you?
State, my lord.
Let me submit her. Well, there was direction for the municipality to either send the candidate list to the director of local bodies, or if they do not wish to proceed with the recruitment process, that can be done. Well, we, as per the new circular from the state of West Bengal, and as per my instruction, we are not proceeding with this recruitment process.
Give a copy to her.
Yes, madam.
Dekhi. Why are you not proceeding? With so much of corruption over there, you want to scrap
But
it?
there is a circular from the state government that now if you have to process, we have to seek all prior permission from the municipal commission. Madam. This is the notification of the state government.
Yes, give the notification.
I think mark, my lord.
Very well. 2014 recruitment process and you are scrapping it in 2025?
Yes, well, direction of this honorable code on 24. We have sent earlier to the director of local bodies the list of candidates.
Please come. Learned advocate representing the Jalpaiguri municipality submits the copy of the instruction forwarded by its chairman signed on 24th of April 2025, which mentions that considering all pros and cons, the municipality has decided not to process with the recruitment process initiated on 27th of June 2014. Stop. The same communication, not same, the said communication has been the said decision has been taken relying on the order dated 3rd March 2025 passed by the Special Secretary to the Government of West Bengal, Department of Urban Development and Municipal Affairs. Madam, I find there is a very good ground to challenge it, but I cannot pass any order over here. Acha. The communication gives rise to a fresh cause of action. Stop lodge. In view of the above, the writ petition stands disposed of. Stop. It will be open for the petitioner to challenge the action of the municipality in a fresh proceeding in accordance with law, if so advised.
Therefore.
Therefore, Lordship. Next. Mr. Shubinoy there?
There is a singular matter, your lordship disposed of yesterday,
Oh.
factor of 2.
Oh,
Compensation.
where is he? Call him, I can dispose it of. Same order করে দিন and just intimate him. কালকে factor 2 একটা ছিল। Factor 2 বলে। You are there? ঠিক আছে। Factor 1, give the yesterday's number or and please intimate Mr. De. $58. What is it?
For the petitioner. Now, this matter is regards to encroachment of the PWD land lordship. On the last occasion, the court directed the concerned authority to file a report. They have filed, a copy has been served upon me, lordship. Report lordship, page 9 of the report.
Yes.
It says that the second party, he has encroached on the.
We have been given opportunity to file it, no, during opposition. We have prepared it.
But wait 1 minute, but the second party was absent. The inquiry, investigation, second party is
LR plot number 831 is the government road, government land.
Yes, what is your submission?
I prepared by evident opposition. My client is a very old man. He resides in a remote village near Naxalban. He couldn't come. He will come on Monday. I'll file it on Monday.
Your opposition or reply will not be required. The revenue inspector has found that you have taken, you have encroached government land. He will take steps accordingly.
One thing. Can you see page 12, page 13? There are 2 civil suits pending in civil court. One they have mentioned, another they have suppressed, and there is an order of the civil court.
You obtain order from the civil court?
No, this is not. Yes, fine.
That is with regard to encroachment in my land. This writ petition is on the encroachment of government road.
Civil court. On his page.
Why is mixing
in both the cases? In both the cases, he has filed. In one case, he has filed a civil suit. In another case, his wife has filed a civil case. So both the cases are pending.
Thing is, whether you have encroached upon a government land or not.
That is not a government land. Number one. That is not it. In those suits, they have said the property belongs to DI fund. Now here he has said that this is a highway. There is a lot of disputes and
you file writ petition challenging the action of the authority.
But let us see that it is further stated herein. Kindly go through the para 30. It is further stated herein that thereafter my client has a plaintiff filed statistic number PS 253 of 15 before learned civil.
Don't go to the suit. I will not look at the plaint, nor I will look at the order of the suit.
Because this application is not maintainable because if it is a highway, it is a PIL, public litigation, public. Where is his right? Where is his right? How he is affected? And this.
The petitioner alleges that the private respondent has made construction by encroaching public land. Stuff.
It is not
from the report filed by the
revenue inspector.
Despite the order of the civil court, he has suppressed these facts.
Revenue officer. It appears
that these are their judgments that this property is if it is a public road, the public is affected. How can the person petition he has is maintainable.
It appears that the revenue inspector, Raniganj, Panishali Gram Panchayat, conducted a field inquiry where demarcation was made, and it appeared that LR plot number 831 and 826 was constructed upon by the private respondent. Stop. The public road is 832.
Government road is 831.
Government road
The
is
GI fund road is 831. I have mentioned in the schedule also.
No, but the report of the revenue inspector doesn't say so. The map is there.
Yes.
PWD road is 832.
PW road is 831, 832. But below that, the 831 is the government road, government land.
Where is it mentioned? Is it mentioned that it is government road?
I have mentioned in my.
Your mentioning will not do. The report of the inspector has to mention it.
It's a government road.
The government is not saying that it is government road. 831
Lot of disputes are there. Lot of disputes are there. I beg to file. There is no opposition. Everybody is opposition.
Achha.
Somehow it said the deaf and heard. Somehow it is said that is a government land. Somehow it is said that it's public highway.
Takes up page number 7 of my report.
7. Is it mentioned?
Yes, plot information report.
Plot information report 831.
831 dark number.
Darjeeling Rayat hocche Darjeeling Improvement Fund.
Another is put in report Darjeeling
Improvement Government.
And another person's name is
Vijay Bhumik 843. 843 is our name. 831. Achha.
Comes within the ambit of the state.
From the record of rights.
Yeah, why it is
Annexed
say
to the
it is
report.
said it is a public highway.
It appears that plot number 831 is recorded in favor of the Darjeeling Improvement
In
Fund.
civil suit, this property, this plot has been prayed for as their fund. And overlooking oversiding this civil suit has filed this application. During the pendency of the civil
instant
suit.
writ petition is this. Learned advocate representing the private respondents oppose the submission of the petitioner. It has been submitted that 2 separate civil suits in respect of the self-same plot of land is pending consideration before the learned civil court. Stop. The paragraph. As the instant writ petition is only limited to the extent of removing encroachment over public plot of land. Accordingly, the instant writ petition is disposed of by directing the
same prayer has been made in the civil court.
This one number 5.
Same prayer, and those are pending.
PWD is not the authority.
The ADM DLRO. 4. ADM LR and
The
DLR.
respondent number 4. The ADM within bracket LR and the District Land and Land Reforms Officer and the Administrator, Darjeeling Improvement Fund Department to take necessary steps for removal of any unauthorized occupant over public land in accordance with law after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed.
Good.
Is the report filed today?
Yes, sir.
Report type to the-
I have not been supplied the copy.
Certainly give a copy. Yes, 59.
I appear for the petitioner.
Yes.
I appear for the petitioner. I appear for the petitioner. This is a matter of compulsory appointment lordship. Father of the petitioner lordship.
Yes.
Father of the petitioner has expired lordship on 31st May 2014 lordship. Thereafter lordship petitioner made an pro forma application lordship as well as the application for the compulsory appointment within 3 months from the date of death of the father lordship. Lordship will find page 30 lordship of the writ petition. Thereafter the respondent municipality authority lordship asked the petitioner to submit the following documents which was mentioned in page 30 lordship. And after that lordship have submitted all the relevant documents lordship. Thereafter lordship will kindly turn over page 31 lordship. That is, you are requested to appear before me on 17 March
What is the
2017
fate?
at 12 noon, lordship. I have complied it. Thereafter,
What is the fate?
lordship, till date lordship, till date lordship, they did not communicate lordship any decision. Thereafter they made a demand justice
Jalpaiguri
lordship.
municipality?
Lordship will find page 33 lordship. Let it be considered lordship.
You have asked the petitioner to appear before the selection committee in 2017.
Yes, my lord. After that,
Thereafter?
I do not have the instruction.
You are keeping this matter pending from 17.
They are recent representation on 24, November 20.
Suppose they do not give any representation, will you not intimate the petitioner the fate of his application?
No, if they have given it or not, I'll come back with instruction.
Take instruction. Please come.
Lordship, earlier question there was a paid time lordship.
Compassionate appointment. Stop. Learned advocate for the municipality is directed to produce written instruction with regard to the fate of the hearing conducted by the selection committee on 31st of August 2017. List when? Tuesday? Wednesday. 30th of April.
My lord, I appear for the writ petitioner.
Yes.
My lord, the writ
Great lords.
on 11th of March to be filed by 3 weeks. My lord.
Supposed to file.
The state.
The statement.
Who are you?
I'm for the statement.
Then you are supposed to file.
My lord, it's not prepared, my lord.
Why?
My lord, from 11th March, it was directed by the Honorable Coordinate Bench within 3 weeks to be filed. Within 2 weeks. My lord, the petitioner had provided infrastructure accommodation during the West Bengal Assembly election 2021.
In the principal bench, the learned AG appeared.
Yes,
2021 election.
Yes, my lord.
Not one, there are series of matters. When will you come with the report? Mentioning the date of payment.
My lord, after 1 week, my lord. And the next circuit.
After 1 week, it's not next circuit.
On the prayer of the learned advocate representing the state respondents, time to file the report by way of affidavit is extended till 8th of May.
I'm grateful.
With a copy to the learned advocate for the petitioner, released in the next circuit.
There was a liberty to file an exception also given if your lordship.
Exception may be filed prior to the adjourned date.
Grateful, my lord.
Grateful.
61, my lord, is appearing for the first time. Here, may I file the affidavit of service, my lord?
I am
Here-
appearing for election question India, my lord, in this matter, my lord.
Yeah, my lord, the writ petitioner had
But my lord, in this matter, my lord, what I was interacting, my lord.
again
So,
electrical for
My lord, this one-
2021 election, my lord, I had provided electrical installation infrastructure work, my lord. No payments have been made till date.
My lord, in this matter, my lord, they have made State Election Commission as a party 2 and 3, but they have served Election Commission of India. So, my lord, in 62 they have done it correctly. I don't know 62, but in
Correct, yes.
61, my lord, they have sent a copy to the Election Commission of India. But
No, State Election Commission is also a party, my lord. Here.
then, my lord, but they have sent a copy to the Election Commission of India, my lord, where I can see it's not a party over here.
Is anybody representing the State Election Commission?
My lord, may I just see the affidavit of service?
Check up. দেখুন তো এটা দিন তো।
After what my learned friend is saying.
But we have received a copy, but in the cost title, my lord,
No, it was sent to the, my lord, Election Commissioner, West Bengal State Election Commission, my lord. It was delivered on 15th of March.
I am appearing Election Commissioner of India. That is what I am saying.
Service is taken on record. None appears on behalf of the West Bengal State Election Commission. Stop. Paragraph. The petitioner claims to have performed certain electrical works in the Assembly election, 2021. Stop. Payment of the same has not been made till date. Stop. Let further notice be served upon the non-appearing respondents. List. Next circuit.
Wait for my lord.
Give to us.
62, my lord, kindly sees the order dated 12th of March of 2025 by the Honorable Coordinate Bench.
Yes.
Here, my lord, I had provided electrical
Same thing.
installation for Lok Sabha election 2019. My lord, there was a direction to file report in the form of affidavit within 3 weeks, my lord.
But here I am appearing for Election India.
My lord, we can file it on Wednesday, my lord. It's not ready, my lord.
Same order করে দিন তো এর আগেরটা যেটা করলাম
60.
না এটা হবে হ্যাঁ লোকসভা yes item 60 তে একটা করলাম না
এটা Lok Sabha
Item
19 আগের দুটো ছিল Assembly election 21.
all the pass না civil motionটা ডেকে নিন।
Grateful, my lord.
Grateful.
Due to some technical defects, I couldn't prepare the affidavit of service because it was served long back.
Technical defect affidavit of service.
It was
You
served
filed it in September 24
28
against order dated 19th
Yes,
of
it was,
December
it was
22.
sent on 28th of September
Then
24.
what happened?
It was sent by the court, but it's not found in track record. Not
Then you have to serve afresh. There is no proof of service upon the opposite parties. Stop. Let further service be made. Established in the next circuit. Affidavit of service shall be
This is the
filed.
document. You know, this is the, in fact, this is a revision application with respect to rejection of my order 9 rule 9.
Sir, there is a direction. 64. Ajay Singhal. None for the petitioner list in the next circuit. Call the passover matter, please.
My lords, I appear for the petition.
Sixty-four, were you there?
I was on next.
Just wait.
Yes.
64.
That's it. 64.
Yes.
My lord, this is the.
Other side.
My lord, this is at motion stage. My
Watch
lord.
CO.
My lord, I'm seeking a short interim order, my lord, because I have challenged a counterclaim, exclusion of a counterclaim. My lord, that was refused by the learned court below. My lord, this counterclaim was filed pursuant to the direction of the honorable court. Now, my lord, the issues are being framed before the learned trial court. My lord, let me serve it upon the opposite party. And I am seeking that till the matter is disposed, the issues with regard, this CO is disposed, issues regarding the counterclaim be not framed. That is my
Your counterclaim has not been admitted at all.
No, my lord, I am the plaintiff. Defendants have filed a counterclaim.
Their claim has not been admitted or
My
has
lord,
been admitted.
I have filed an application seeking for exclusion of the counterclaim.
Exclusion of the counterclaim. All right.
And impugned order has been passed. My lord,
Allowing
kindly
it.
sees no reasons has been assigned.
No reason
In a
may have been,
cryptic
but
manner.
then you say it has been done pursuant to the order. Counterclaim has been filed pursuant to the order of the court.
No, my lord. My lord, I had filed, first the counterclaim was filed. That I had challenged by way of Order 7, Rule 11.
Yes.
Honorable Court has disposed that application with a liberty to file appropriate application because Order 8, there is a specific provision for exclusion.
So instead of filing a separate suit, a counterclaim has been filed, which you are objecting.
Now, my lord, in the entire counterclaim, the allegations are against the persons who are not party to the suit, neither they are
Whatever
made.
it is. Acha, the order dated 27 February 2025. Passed by the learned trial court. in title suit 41/19 within bracket 08/19 is impugned. Stop. Let notice be served upon the opposite parties. List in the next circuit.
My
I'm
lord,
not
kindly-
passing any interim
my
order
lord,
only
to
because of the
extent
reason.
To the extent that issues with regarding to the counterclaim be not framed till the matter is disposed, my lord.
Not disposal next, in the next day, let them come and then you can make this prayer.
My lord, the date is fixed with on 5th May, my lord.
Doesn't matter if this is pending and order has been passed, no difficulty.
I'll just inform the court
Yes,
about
please.
dependence.
Yes, possible. 4.
Lords, I appeal for the petition.
Yes, yes. Where is he? What is it?
My lords, this is an application filed seeking stay of operation of the impugned assessment order which is pursuant to the impugned notice under section 148 of the Income Tax Act. My lords, I'll give you a brief. I had challenged in this writ petition a notice under section 148 and order under section 148AD, which is the reopening proceedings, my lords. Under reopening proceedings, my lords, there is a procedure laid down in under 148A. They have to issue me a show cause notice under 148AB. Thereafter, I'll file my reply, and thereafter they will decide whether it is a fit case to issue notice under section 148. I had challenged 148AD order and 148 notice. My lords, at the first stage, when the matter was first heard, my ground was that the information on the basis of which the entire reassessment has been initiated was not supplied to me. Inter alia, one of these grounds was pleaded by me. The court did not grant me any interim relief on the premise that I had not specifically requested for that information from the authorities. The matter proceeded subsequently and the assessment order was passed. My lords, what happened after the filing of the writ petition and after the admission of my writ petition, I filed an RTI with the Income Tax Department and I received the note sheet of the entire order sheet. From the note sheet, my lords, it is apparent that the assessing officer has circulated 3 draft orders under section 148AD. In the first 2 orders, he says that it is a not fit case for issuance of notice under section 148. And after getting directions from his superior officer, who is the principal CIT, which is apparent from their note sheet, he changed his view from not fit to fit case. So, my lords, this fact I was not aware when I first moved this writ petition.
So you filed an application.
I have filed an application because, my lords, I have to prefer an appeal against the impugned order. My writ petition is pending because I had challenged the 148 notice. Now, my lords, if this interim protection is not granted, I will lose my remedy, my lords, because the notice under section 140 is this the foundational notice under the Income Tax Act. If this goes, the entire assessment will go. So my only prayer is let this matter be decided so that I can pursue my remedies. Because if I am successful here, I don't need to go there for appeal. And since, my lords, this matter is pending, I cannot raise this issue before the appellate authority.
All right, but then you have filed an application for stay.
Stay of operation of the assessment order as well as the notice of demand.
All right.
Till the matter is pending for disposal.
Lordship, once the assessment order under section 147 was passed, this order was the appealable order. In this writ petition, first they challenged 148 notice and 148 Honorable Court did not pass any interim orders. Now subsequently he participated in the faceless manner. Faceless manner proceeding, your lordship, 147 order was passed. Once the order was passed, that is the appealable order and the stay granted against deposit of 20%, your lordship. That is the situation. And your lordship, they filed only CAN application. In the main writ application, on that time assessment order is not passed, your lordship. Then afterwards passed. So once the part, this is the appealable order. He filed an appeal against the 147's assessment order, deposit the 20%, grant the stay automatically. That's the law.
No, he doesn't want to deposit because he says that the initiation was wrong.
Yes.
Lordship, this point, your lordship, we have several judgment.
Yes.
Learned DSG and online. Your lordship.
No, ma'am, please continue, Mr.
Complete.
Singane, please continue.
Now, your lordship, there are several judgments. Even if our coordinate bench in others cases, 148D and 148A challenges, the SSC has permitted
No,
to
what is to be
challenge
done?
before the appellate
Will you-
authority, then the tribunal, then the.
Will you file any opposition to
Lordship,
this
lordship, lordship. I'll deal
stay
with your lordship.
application?
Yes, lord. Yes, that is my main prayer. Your lordship. I'll file this opposition against this.
My lords, my time to file appeal was expiring on 21st April 2025. I filed this application on 1st of April. This was affirmed on 2nd of April. So I had come before time, my lords.
Very well, whatever will happen will be seen. Please come.
I'll
The
file
petitioner prays for stay of the assessment order
I have passed under section 147 faceless manner, your lord.
passed under section 147 and the demand notice under section 156 of the Income Tax Act.
Lordship.
Lordship, I also wish to challenge the very maintainability of this CAN application.
ঠিক আছে. The maintainability of the connected application has been challenged. Stuff. The respondents seek to file affidavit in opposition. Stuff. Let the opposition be filed within a period of how soon? How
Lordship,
soon?
Lordship, 2 weeks. 1 week, let my up. 1 2 weeks. After circuit, 1 week.
My lords, let them complete the hearing of this matter. I am ready. Affidavits have already been exchanged.
2 weeks করে দিন 1 week reply next circuit. Please don't pray for further extension because he is already losing time.
Yes, my lords. That's it. That is my
Within
only
time.
grievance. That is my only grievance, my lords.
Within time.
My lords, some observation to that effect, my lords.
It will not be
My
proper.
time limit is expired
I
already.
understand.
Then also the applicable order is the.
You can get that relief at the final
And-
hearing
yes, yes.
stage.
I'm grateful.
Next.
Obliged, ladies.
My lord, before my lord takes item number 7, if item number 49 is taken, my lord, because I have a matter fixed before the principal bench, my lord.
I'll pass it over. Keep some of your friend. Any of your friends?
For the state, in that matter, my lord,
I mean,
petrol pump matter, my lord.
Oh,
Petrol pump, that matter.
Wait, I'll go serially. Otherwise, it becomes difficult.
In this matter, I'm for the university, my lord. He has taken the all pensionary benefits also, my lord.
Yes. What is his prayer? I do not know. What
He
is your
said that-
submission? What is your submission?
was-
What is your case?
I was given a notice
Yes,
19 months ahead of my actual date of retirement,
right.
and I was sent into
Show
retirement
me
with,
the impugned order. Page 16,
yes, ma'am.
14th of June.
P1,
P1.
12.
21st of February.
Notice was given for his retirement.
Retire from service on 30th of June. After attaining the age of superannuation, 60 years of age.
Yes.
Yes. How are you aggrieved? What is your date of birth?
There is no verification, in spite of having given a written
How many years service did you perform?
19,
was your
19 months
appointment?
less than,
When was your appointment?
it was in 1986.
From 86 till 24, you did not find time to correct your date of birth.
It was given,
Where was it given? Any proof?
page 14,
Yes.
P3. The actual date of birth is given in this. And it was
Transfer
at the time of my appointment, this was given.
Where is your service records? Where are your service records? Where from will you show that page 14 was before the authority at the time of giving appointment?
I'll seek instructions from my client.
No.
I'll have to seek instructions from my client as to the service records as such.
How was
These
the
are the only
petition?
documents that.
That means your client does not have anything else. He is relying upon page 14 after this order has been passed. This is the only presumption of the court, isn't it? And what is to be done? The writ petition is to be dismissed.
I'll have to take further instructions. If
And-
I'm given an opportunity to come back again.
And the impugned order, page 12, was in February 24. You filed the writ petition in April 25. Very good reason to dismiss it. When will the dismissal be?
Opportunity.
One opportunity, Monday.
I too busy to the pension.
Keep it on record. I'll dismiss it on Monday instead of today. Let him also be satisfied. আচ্ছা একটা order record করুন তো. The petitioner seeks correction of his date of birth after an order of superannuation has been, not order, but notice of superannuation has been issued. Stuff. It appears that the notice of superannuation was issued on 21st of February 2024, intimating the petitioner that he will retire from service on 30th of June 2024. Stop. The instant writ petition has been filed on 8th of April 2025, disclosing a transfer certificate allegedly issued on 17th of January 1985, mentioning the date of birth of the petitioner as 7th January 1966. Stop. There is no document annexed to the writ petition in support of the submission that the date of birth as recorded in the transfer certificate was recorded in the service records of the petitioner. Stop. It is settled law that the date of birth cannot be changed or rectified after the notice of superannuation is passed or immediately prior to superannuation. Stop. Paragraph. Learned advocate representing the petitioner seeks time to take further instruction. List on Monday.
Monday.
The instruction by the, is it instruction or order?
This is his application.
আচ্ছা ঠিক আছে application. ঠিক আছে যা আছে be written with the records.
He recorded his date of 1/7/1964.
Item number 11.
Lordship, item number 11, I beg to appear on behalf of the petitioner, Your Lordship.
Yes. Lordship.
Your Lordship, in this
Learned
matter,
additional advocate generally will appear, but his one matter is going on in the principal bench. Lordship, kindly fix the matter.
Till now in the principal bench.
Lordship,
What will be
Lordship,
done?
kindly make it not today, Lordship.
my lord, this is petty matter, Lordship, small matter, Lordship. In this matter, the petitioner has lodged an FIR, Lordship. This FIR was not acted upon.
Private respondent has filed Vakalatama?
Yes.
All right. Do you have instruction?
Lordship, I have the instruction addressing to additional advocate general.
Yes, let it be kept with the records.
Lordship.
Instruction written with the records on the prayer of the learned advocate representing the state respondents. The matter stands adjourned for the day.
Lordship, it will be difficult for me to do it on Monday. Kindly, it may be kept on Friday, Lordship.
Friday,
Lordship, please.
the last day of the circuit.
Lordship.
Very difficult.
And it will be placed on the next circuit.
In that case, I'll place it in the next circuit. I'll keep the records. Whatever is given by the state, written with the records, list in the next circuit.
Later copy.
Lordship, much obliged.
I do not know because this is
This is
whether
addressing to additional advocate general.
yes, whether it can be served or not, I do not know. I have not gone through it. So it's better you make this prayer in that before the next circuit.
Okay.
Next circuit.
28.
কত? 28.
Number 28.
My lord, I am the
28. Yes.
my lord, petitioner is paying for A category payment scale, my lord. After completing the DLA, my lord.
হ্যাঁ ঠিক আছে অর্ডার হয়ে গেছে ডিসপোজড নেক্সট
35.
35 35
Lordship, for apology. Item number 28, I was on my legs.
who are you for?
For the DPSC.
I appeared on behalf of DPSC, but the question is, the officer not being served upon me.
Lord, I will serve.
Your name be recorded, copy will be served, there is a direction for consideration. All right?
my lord, one indulgence, my lord. In this matter, my lord, the petitioner straightway filed this writ application. So my only humble submission is that, my lord, kindly treat this writ petition as a representation. And my lord, after considering the record, if I am, my lord, eligible.
Order this name. Order. Yes, sir. Just wait, just wait. পরেরটা ডাকুন একটু।
35, my lord, I am for the petitioner. Lord, the 35, I am for the petitioner. Lord, the petitioner seeks transfer from Jalpaiguri to Malda. You will also kindly turn to page 54. Utsoshi application, status of Utsoshi application, 35.
এটা 35? Page?
Page 54. Only one application was made on 14th August 2021. You will also page 54. From the bottom, my lord, on upwards, 14th August 2021.
Who is for the West Bengal School Service Commission?
I have served, my lord, only direct the School Service Commission to consider that. My lord, the single teacher concept, my lord, the division man held, my lord, the page 72. That
Usually Sunit Rai is appearing.
Yes, where is Mr. Roy? Is this a single teacher, subject teacher transfer case?
Yes.
Now he's frozen. Where is the impugned order? প্রদীপ চেঞ্জ হবে এখানে পুরোটাই হচ্ছে রিপ্রেজেন্টেশন ফাইল করা হয়েছিল এটা কোনটা এটা ভুলে গেছি School Service Commission, nobody is there. Where is the impugned order? Please show. 54. It has been redirected. Sent back to the School Service Commission. General transfer back. Meeting council, recommendation, single teacher. Achha, this happened in 2021. Thereafter, there are so many other orders.
No, that is
That they are similar orders, not in your case.
similar.
Achha. Do one thing. ওই কালকে ইয়ে ছিল না ওই সিঙ্গেল টিচার ট্রান্সফারের একটা মেমো আপনি নিয়েছিলেন সেম অর্ডার করে দিন তো সিঙ্গেল টিচার ট্রান্সফার yes জানুয়ারি সুমিত রায় অ্যাপিয়ার করেছিল জানুয়ারি 2022 একটা নোটিফিকেশন আছে সেই নোটিফিকেশন অনুযায়ী দেখে কনসিডার করতে হবে ঠিক আছে
35.
yes হ্যাঁ আচ্ছা এটা কোনটা ওই এ স্কেলটা দেখি এ স্কেলের অর্ডার ওই ফাইলটা দেখি দুটোর কোনোটাই হবে না এই রিপ্রেজেন্টেশনই দেয়নি প্লিজ কাম দ্য পিটিশনার সিক্স এইটা এই প্যারাগ্রাফটা থাকবে এটা হচ্ছে না এটা থাকছে ঠিক আছে it appears that instead of approaching the concerned authority, comma, the petitioner has directly filed the writ petition before the court seeking a category scale of pay. Stop paragraph. The instant writ petition is disposed of by granting leave to the petitioner to file a comprehensive representation disclosing all facts and annexing the time schedule, the timetable for appearing in the DLED, DLED course.
No, it is a space 24. The
ঠিক আছে।
timetable.
In the event such a representation is made, along with supporting documents, comma, the same shall be considered by the chairman, District Primary School Council,
Being the respondent number 3, madam.
জলপাইগুড়ি। ঠিক আছে? In line with the decision passed by the Honorable High Court in WPA, এটা টুকে যাবেন, order dated এত, ঠিক আছে? এই ডিসিশন বলুন, এগুলো হচ্ছে না, order dated এত, হ্যাঁ, আচ্ছা, a decision shall be taken in the matter at the earliest, but positively within 12 weeks করা আছে, এটা 8 weeks করে দেবেন, 8 weeks from the date of submission of the representation.
Yes.
ঠিক আছে? এটা হবে না।
35.
Disposed.
Extremely grateful. 49, I'm for the state, my lord. No, my lord, no, I have a matter.
Not today.
Not today.
Hmm.
My lord, kindly pass through the hearing took place, my lord, between petitioner and the state, my lord, if our order is recorded.
Why, no hearing took place. See, he's gone.
49 million for the petitioner.
Petitioner is there, my lord.
Who was that?
BPCL, my lord. They are doing this, my lord, repeatedly, my lord.
Call him, call him, call him, call him.
They are not bringing
Call
the
him,
lease
call him,
agreement.
call him, call him. I thought he was for the petitioner. Are you there? Where is your learned counsel? If he goes on appearing, then I'll pass ex parte orders. The court will be bound to pass ex parte orders. Then somebody should be here.
There are two councils, my lord. So we
Where
are
is-
also there.
Yes. No, it cannot be done.
They are not bringing the lease agreement, my lord.
All right, I'll pass it over 1 second. I'll pass it over 1 second. Yes, call the next one.
My lord, there's 130, my lord. My lord.
I'll take up the hearing, then come.
Item number 53, your lordship, I'm appearing on behalf of the petitioner, your
Yes.
lordship. There was a direction upon the respondent to file a report in the form of affidavit.
Not
your lordship.
filed?
I'm for the respondent.
Just served.
Just served.
All right, you take an exception.
Yes, your lordship.
Report filed by the
Respondent.
Which respondent?
Union of India and
Achha,
others.
filed by the respondent.
All
union.
respondent.
সবাই বোধহয় union respondents. The railway is also there?
Yes.
আচ্ছা, তাহলে respondents. Taken on record.
Sir,
Respondent
it
number
is,
1, 2, and 3.
am I
There
audible,
is a
madam?
private respondent also.
No, Union
They are not the
1 to 4, 1 to 3.
They are not the answering respondent in the.
Maybe, did you serve
But
the
yes,
respondent
your
number
lordship.
4?
It must be with the
Achha,
affidavit of
তাহলে
service is on
the
record,
1,
your
2, 3.
lordship, and
ঠিক আছে।
after hearing, there is a
Learned
your
advocate
lordship.
for the petitioner seeks time to file exception to the same stuff. Let exception be filed within a fortnight.
Lordship,
Stuff.
within a week, your lordship, let the matter appear on Friday, if possible, your lordship.
Friday it will not be possible.
Your lordship, by the order dated 19th of February 2025, there was a stay of operation of the tender proceeding for 2 months, your lordship. So if that could be extended, because the opposition had to be filed, interim order that is subsisting in the matter is extended till 30th of June 2025 or until further order, whichever is earlier, list in the next circuit. Great, your lordship. Yes, call. Yes, 65. Yes.
Judgment.
Ringtone.
It's not.
Lordship, it pertains to keyboard.
Your junior is here.
No, it pertains to keyboard, Mr. Roy.
Is it a T-board matter?
Yes, yes.
My lord, other coordinate bench has directed Mr. Roy to bring 6 packets of tea leaves, which hasn't not done. So he can't be heard, my lord.
Without the packets of tea.
I'll give him.
No, my lord, he cannot
He
keep on
says
promising, my
6.
lord.
Provide 1 dozen.
Six, I'll give it today. No. My lord, this matter is. I have challenged. Here, my prayer is that my lord, if she can come to my and come to pace. My lord, pace 28 and 29. I prayer. Once this matter was heard by your lordship. In this matter, I must. Notes of arguments are maybe there.
Notes of arguments also there.
Yes, yes. What one you want?
These are the judgments.
Yes, yes.
So many judgments.
Yes. Judge, I being again.
Wait, let me find out the writ petition first.
Yes. My lord, in this matter, boss. In this matter, I am praying for.
Yes.
My lord, disbursement of the subsidy. Your lordship, the petition having the tea estate.
All right.
The tea board, the central government introduced a scheme for granting the subsidy in favor of the petitioners. That was
Petitioner, who is the petitioner?
just tea garden, tea estate
Garden.
matter.
All right.
So first that they failed to disburse my that subsidy or financial incentives. Second, I have challenged the declaratory relief. The news on the new scheme, they have taken away my pending, all the pending claims are revoked or curtailed by one clause, the new scheme. So I ask for that declaratory relief that this is
not applicable.
Not, it's opposite Article 14 of the Constitution. This is my two peers. Now, if you also kindly come to page 32.
Yes.
And this is the scheme. The scheme is called, my next page is relevant. This tea development and promotion scheme during 12 plan scheme. The government India has conveyed its approval to the tea board scheme to tea development and promotion scheme for implementation during 12 5 years, 2012-17 by this. So the central government's plan that was approved by the central government, and it would be nodal agency is the tea board, my lord. Now you also can see the components. Component 1 is plantation development. Well, Mike, you also got it. Can you come to next page, my lord? Page 35. At page 35, under plantation development, some sub-components. And see, plantation development under, there are 5 sub-components under this component. I am considering replantation, replacement, planting, rejuvenation of old tea bushes. I applied for subsidy under
for this subcomponent.
Rejuvenation.
Replantation, replacement planting, and rejuvenation of all tea bushes. So this is my application. Now you will can come to page 37, 39, to 37, 39 of the scheme. But before that, I should place it that page 37. What are the 37C activity specific eligibility conditions? These are the conditions are given, and I have to fulfill. Now you also can come to page 39. These are they have 39. They have given the all eligibility conditions. Now, my lord, page 42. Page 42 is very relevant.
What is page 39?
37 to 39.
37 to 39.
These are conditions I have to.
All right.
They are general conditions. Otherwise, I can't come. Now the relevant is page 42.
42.
Submission of application. I just for all the subcomponent activities, the application for subsidy shall be submitted in the prescribed format, complete in all respect with the supporting documents to the nearest officer T-board 30 days before the commencement of the field operation or procurement items. Documents to be submitted along with the application, these are all prescribed. Now, my E, page 43. Pre-approval inspection. A pre-approval inspection will be carried out by the field office of the board soon after receipt of application from the gardens to justify the need for undertaking the relevant operation for which subsidy has been sought for. However, pre-approval inspection is not required in this field. I'm not coming. On completion of pre-approval inspection, a no objection certificate will be issued by the concerned field officer for proceeding with the field work or procurement of items. And the field activities have been commenced on the on items or materials that have been procured prior to pre-approval inspection by the board. Field officer will not be eligible for any financial assistance. However, these conditions shall not relax or the issuance of NSC has unduly been delayed by the field officer or field activity has been undertaken. Material procured after 30 days from the submission application to the board. Next, my lord. NOC issued by the field officer shall not be binding on the board if application was subsequently found to be ineligible for subsidy due to other reasons to be specified by the board in writing. This clause of E. The commitment of the board will become binding only after issuance of the approval cum sanction letter following the scrutiny of the post-operative inspection report. And coming. So, my lord, this is settled law. No objection certificate does not get any rights to get the subsidy. It is like a promise or representation. So, I have to act it upon. And when I acted upon from the post-operative inspection, if it is found that I did it satisfactorily, then I entail to get it. So then question of sanction letter be there's a necessity of the sanction letter. So there are three parts. No object first pre-approval inquiry. They would give the no objection certificate. On getting no objection, I did not get any right. On the basis of no objection certificate, I have to execute the work. And after executing the work, during post-operative operation inspection, it is found that I complete the work satisfactorily, then I am entailed to get the benefit, then they will the sanction letter. But secondly, in case of rejuvenation, sanction letter provision is not there. No specific provision is not there. You have to get the sanction letter. I'll show it. So, my lord, now I place it. So, their submission is that NOC, no, I'm not, it's not binding on me. Financial commitment is not binding on NOC. Subsequently, I have to carry on all the works. Now, can you see first inspection, post-operative inspection. The inspection will be carried out at the field officer, development officer, assistant director board soon after receipt of information from the applicant guardian to the completion of field works, replanting, replacement painting, replacement, uprooting of the required percentages, rejuvenation, pruning and infilling with or without interplanting, extension planting, procurement items for which subsidies being claimed. And the applicant garden should produce a post-activity survey map in respect of replantation, replacement planting, uprooting, rejuvenation, civil works related to irrigation as the case may be. In case of procurement, I'm not this concern. See, satisfactory, this is very vital. Satisfactory completion of field work, replanting, replacement, planting, and uprooting of the required percentage, rejuvenation, pruning, and infilling with or without interplanting, extension, planting, or procurement, field mechanization until commissioning and irrigation equipment, and the same be offered for physical verification by the field office of the board. And my lord, receiving the supporting documents along with the inspection report from field officer will entail the applicant guardian for receiving of subsidy. So my lord, NOC is a first step. Then I execute the work. And the field, there's a field inspection, post-operative field inspection. If the field inspection found that it is completed satisfactorily, then it entails me to get the benefits. Then, my lord, commitment of the board will come. So, my lord, my submission is there are 4 steps. First, I have to apply for, then pre-activity inspection, then NOC, then, my lord, execution of the work, then, my lord, post-operative report by their field officer, whether I done or not. See, immediately they have given that, yes, I completed the work satisfactorily, I am entitled to get the benefit of subsidy. And in case of replantation, there is no specific provision that sanction letter should be issued. This is also one of my points. Here, what happened? Can you see? Well, if you only see the affidavit opposition. But people can come to their opposition at page 21, 22. Yes. I see they have annexed these moralities regarding payment, the 12-month scheme. Consumer, I am directed to convey the approval of the competent authority, the modalities and scheme guidelines for implemented 12-month scheme, key development promotion scheme for a total plan outlay of rupees 1425 during the period 12 to 17 million. So they say the central government has already provided 1425 crores for this plantation. Now they have given the clauses. Can you see the 3? The financial and physical targets of the scheme shall be adhered subject to availability of fund provided to board under plan by Government of India through budget appropriation. My lord, this is their scheme. Next can come to base. The readymade is Roman 8. Procedure for receiving applications for availing benefits of the scheme related to defined components shall be transparent, simple, appropriate, and use-friendly. Efforts are made to provide online service wherever possible. But 11, the board may devise a monitoring mechanism for effective implementation of the scheme. This is our guidelines. Now, my lord, my case is, if you can come to page 197.
Mr. Singhania, why don't you sit? Is there a chair? Yes, yes, take your seat. Yes.
Said him.
Ah, it's all right.
Kindly come to page 197.
Yes.
And you see, this is no objection certificate. First notice is given in my favor. This date is 30th December to the 15th. I applied, this is page at 19, sorry, my lord, I should.
Where is this no objection mentioned?
Yes.
On 97?
Second line.
And
I am to
there is no
inform that
objection,
there is
yes.
no objection.
Hmm.
But because I just placed the application, then I should. Can you come to page 19? No, in 1920, I'd say, oh. Sorry. It's 197. I'm coming. Right, 197. So, my lord, I applied for, they have given me no objection for starting to commence uprooting, replanting, and rejuvenation, pruning of this work they have given. So 30th December 15th they have given. Now your lordship can come to page 199. My lord, this is page 198 I should show, 98 last. It may be noted that this note NOC is being issued only with the object to enable you to commence and complete field works within your time schedule without any financial commitment on the part of the T-board as this states. So when it is NOC will not give
Create any right in your favor.
but it has given me right or scope to execute the work. It's like a promise. Now can you come to page 199. My lord, after completion of the work, I intimated them. Now the inspection report. First inspection report. In request by the applicant, he stated by letter Sergeant Anderson has personally visited the above mentioned key estate dates stated above in order to verify the progress of pruning and infilling the rejuvenated area under T-board's T development scheme. Sub-component inspection was carried out in the presence of the scene. The manager of the garden certified the details noted have been verified from the garden records and observation at site. And can you say date? Date of commencement of pruning. On 16, we have started. Date of completion of pruning, we have given pruning and date of completion. Then, my lord, can you see recovery of the rejuvenation business found to be satisfactory. You see the remarks given. Now, can you come to the next page? Let's say certified 2. So confirm that rejuvenation pruning has been carried on satisfactory in terms of the approved boundary in keyboard, office letter, and terms condition subsidy scheme for rejuvenation of existing areas. So they say, I execute the work satisfactory. So post-operative report, my lord, and it is endorsed by the field officer post-operative report that I execute the work and complete work satisfactory. Next, my lord, can come case 201. This is a part of when kindly infilling of vacancy without interpreting. And then this is also next part of the work I done. One infields have established satisfactory. Next can come to the two, they said same thing. So my lord, with first pruning, then replacement, then infilling, my lord. The done now you also can come. Yes, 2003, my lord. 203, my lord.
Yes.
This is my second final report. The two reports, first report, second final report, they have done. That's it. Rejuvenation bushes with infill plants are being maintained satisfactorily. So these all the stages I have done. The 4 stages I have done. this is really one NOC. Next NOC, my lord, can you come to page 205?
Yes.
My lord, I also arranged the documents in reply when I intimated them. This I just place it. Can you come to page 205? This second NOC was issued for the next one. My lord, last, it may be please be noted that NOC is being issued with the object to enable you to commence and complete the work. Is got it, madam? 29 November 2016. NOC was given. Now it is for uprooting and rejuvenation. Next, my lord, 2006 is the second inspection report. Can you come? Same happened. The officer like rejuvenated bushes with infield plants are being maintained satisfactorily. This is my lord, 2000. Consider this is 2021. My lord, at page 207, the garden has been granted installment facility for registry of peer commission. There is a peer now. Extra NOC beyond the stable period. The garden has applied for extension NOC beyond the stable period for including and the according the component and the company of the granted the space by this later.
Is it for the same garden? Achha.
Actually,
Then why
sir,
two inspection final report?
NOC for one part.
All right, I get it.
It's all NOCs. Now, my lord, can you come to 7, 8, 7? Now, again, can you come to 2010? I'm also the 3 NOCs.
All right.
2010. 2010, my lord, same as NOC was given in 17. For other, this is a different part of the tier.
All right.
So 2011 is the my lord final inspection report.
Yes.
Same. This is satisfactory.
Yes.
These are under the 12 plan scheme. Now next scheme has come, MTF scheme. I'm coming before that. My lord, I show some documents for my reply. They say they have taken the point. You have executed work after expiry of the scheme. So for this, I show the NOC, I execute work, I intimated them. They conduct this afterwards. This is not my headache. I'll show. If you also can reply, page 19, 20. 19 and 20, 19 to 22, I intimated them on May 26, 27, 17. Here's that. Pursuant to our earlier letter regarding request for first inspection, you have completed RJP and including in these areas and request you to complete inspection at the earliest possible. So I have given the intimation on 26 May 2017.
RJP. Post RJP.
I
in filling
RJP rejuvenation.
rejuvenation.
And pruning. Rejuvenation and pruning. And
Alright.
filling in our this abbreviation really.
It is not pruning, Mr. Roy, it is planting.
Thank you.
Tea garden owner does not know what is this.
Yes, I thank you, thank you. So we have completed the RGP rejuvenation and planting and including these areas to complete the inspection at the earliest possible. This one on May 26, 2017. Well, then this letter continues. Next one, my lord, 23-25. We intimated on 1st April 2019 at page 23. for second NOC, we intimated the 1st April 2019 at page 23, my lord. You got it, my lord? Next, my lord, at page 26. And this is very important. I given on 3rd September 2021, although we have completed the RGB infilling in respect of the account to 16, 17, 18, 19, the inspection reports are still awaited. So they have done afterwards. So I intimated them. Now, my lord, the next team has come. You also can see. So the scheme has expired, new scheme has come, that's page 252. This is a new scheme.
Page?
It starts from page 252. This is called T Development and Promotion Scheme.
Where is this 252?
252.
Your petition is of how many pages?
No, there are 2 volumes. I might not get in there. The 2 volumes. Because this is a
Big garden, big petition. Big garden, big petition.
2 volumes. Sir.
2 volumes or 3 volumes?
3 volumes. Because our rules now.
252, yes.
252. The new scheme has come into force. This is called T Development and Promotion Scheme for Medium Term Framework. Starts from 29 December 17 to 31st March 2020. So this is called MTF scheme, my lord. Well, what I'm trying to, the objects are same. All are same. My lord, I'm sure, and page 256 is very relevant.
Yes.
The saving clause are here. The objective of this component is to increase production and field productivity and quality of tea by encouraging replanting, replacement, planting, rejuvenation, pruning, irrigation mechanism overall, the small tea growers to help to move up the value chain. Sustainability of production by promoting organic tea cultivation, special package for Northeast district and Kerala, Himachal Pradesh, Uttarakhand have been devised by taking care of the special needs of these pending claims for applications submitted under 11 and 12 month schemes. In the small tea growers will be accommodated during the medium term framework scheme to be governed by the guidelines that were framed under the respective schemes. So those are my pending claims. Those are set under the new scheme because the objectives are set. This is very vital. Page 256.
Yes.
Well, under this scheme also I applied for. This is at page, my lord, 210.
210. 210 is the old NOC.
Sorry. No. Yes. Page are my guy 213. MTF scheme. Now they have
New scheme.
MTF scheme.
MTF scheme.
But they said now the nomenclature has been changed. They in place of object is a pre-activity acknowledgement receipt. Pre-activity, but this is the notification has been renamed as this. This is given 2nd December, January 2019. My next 2014. There's an inspection report. They say it is satisfactory. Both the schemes are objects are same. 2018 is the second final inspection. That's done on 31st March 2022.
213 is 2019.
Yes.
Then
Well, that is a
2014 is the first inspection report
On
in terms of the
31st
MTF scheme.
yes.
All
31st
right.
March 2022.
Right.
Then, my lord, this is the first inspection report,
Huh.
and 2018, the second final inspection report.
Yes. All right.
So, my lord, in gist, my lord, NOC was given or prior to the inspection.
Has there been any formal rejection?
No, there's no rejection pending.
It's still pending.
No, by this new scheme, they have, I'm coming. And
Hmm.
you they have curtail or all rights. They said, no, we are not entitled.
Where has they said it? By way of affidavit or by passing a
No, in
fresh order?
the scheme is
In
next.
the-
I'm coming.
All right.
I come. So, my lord, what I'm trying to submit, my lord, from these documents is show, my lord, the scheme says NOC will not give you rights. I'm sorry, I'm repeating. I'm same. But NOC is giving you right to execute the work. If I execute the work, and that has been certified by their field officer that I did it satisfactorily, I am eligible to get the benefits. This is a substantive part I have complied with. Procedural part is when I am placed a Supreme Court judgment. Supreme Court says there's two parts, one procedural part, one substantive part. If you comply with the procedural substantive part, whether sanction letter was given or not, this is a very procedural part, I'll show. So I have everything has done. That post inspection report is given. They are kept it pending. They kept it pending on the ground of.
Yes, I followed. There
Now I'm coming. Why they have kept it pending?
Hmm.
If you also kindly come to page 357. He produced my one RTI latest manual by one of our friends have given. And you see, first questions. Please provide a copy of the letter communication issued by the competent authority to T-Board directing them to hold back the issuance of sanction letters. Producers who have been issued NOC under T-Development scheme. In order to strengthen the financial management against different schemes of the T-Board based on fund availability, it was felt necessity for assessment of application status at field office level. In line with the copy of the letter, two letters they have enclosed. One is 259, 359, it's going to come 359. Or next one is the letter. In order to strengthen the financial management against different schemes of the T-Board based on fund availability, it was felt necessary for assessment of application status at field office level. Now you also can come to page 359. This is a letter. They say why they have not given.
Yes.
This is given to all T-Board's letter, directed to state that it has been absorbed by the CA, that competent authority, that there is an urgent need to strengthen the financial management of the subsidy scheme so that no additional liability is created in sync with the budgetary allocation made by the government. It is accordingly necessary that sanction letter be issued only to the extent of fund available, and under no circumstances sanctions should be issued that can be settled due to want of funds. Sanction letters should be issued only after ascertaining fund availability. The financial advisor chief accounts officer will intimate the exact allocation made to the different office which cannot be exceeded. Any additional expenditure made if the scheme is to be operational beyond 1 year has to be reflected in the return so that provisions can be made for payment to the next 1 and 2 financial years. In case of sanction is issued without fund backup, a sanctioning officer will be held responsible. Why they have not issued the sanction letter, my lord? This. If they issue a sanction letter, they will be responsible. Next letter will come 361. And this is it is noticed that it's a financial advisor is given that a large amount of liability which is under audit has been created towards disbursal of subsidy without allocation of any additional fund by MOC. Fundamentally, the sanction towards subsidy disbursal should be restricted up to the allocated budget. Since 1920, it is last year of MTF, all out efforts should be made to clear the liabilities first before creating any fresh liability. So this is paradoxical. Once they said, unless fund is given, now they say yes, to accelerate it, to pay the fund. Similar, they can't say that I'm in a fund. Their own letter shows they have not given it because of the dearth of fund. My lord. We come to page 362. With regards to the above mentioned subject, a team for development directorate campaigning schedule from 24 February 20 for resolving various issues related to subsidy matters. The team from Calcutta head office and the local keyboard officers would be stationed at Jalpaiguri to discuss, deliberate and resolve the issues pertaining to the disbursement subsidy amount allotted to North Bengal, including committed liabilities. Therefore, all concerned stakeholders are requested to contact the officials for direct resolution disburse the subsidy amount to the best possible extent as per existing guideline of keyboard. The boards also expressed deep regret over the misunderstanding of allocation of subsidy amounts of North Bengal between NR and ONER, which seems to have created feeling of neglected tea garden of North Bengal. Additional allotment is being made by the MOC. The committed liabilities will be cleared and ESP and receiver application will also start. This is letter, my lord, can you see 24 February 2020. They are processing it. Now you're standing. I can 363, the other letter. Directed to inform that the field inspection of various plant scheme, digital verification would not be carried out due to restriction of movement as imposed by the government due to COVID-19 pandemic from 8 June to 20. West Bengal and other states have allowed these activities in their recent order. All the cases be kept in readiness for sanction subject to availability of fund. They then says, keep it ready for sanction, subject to fund. Hello. My manifest is very candid. They've annexed on document at page 35 of this, the opposition.
Yes.
This can you see? This is a government of Ministry of Finance, Government of India. Minutes of the Expenditure Finance Committee meeting held on 3rd June 2021 to consider Department of Commerce proposal of tea development for scheme for continuing during the 15 FCP. The undersigned is directed to refer to EFC meeting, the subject cited above. For here is copy of minutes of meeting with the approval of the Finance Secretary and Secretary. Now report, madam. I just place it. Minutes of the meeting of the Expenditure Finance Committee held on 3rd June 2021 in Press Room, North Block, New Delhi. Chairman of Finance Secretary and Secretary Expenditure, also Department of Commerce proposal for continuation schemes being implemented by T-Board for 21, 22, 25, 26. The meeting of the Expenditure Finance Committee was held under the chairmanship of the Finance Secretary and Secretary Expenditure on 3rd June 2021 at 3 p.m. in the fiscal room to consider the proposal of Department of Commerce for continuation scheme being implemented by T-Board for pure 21, 22 to 26. The chair welcome of the members and invited Department of Commerce to present the proposal. T-Board made the presentation highlighting and achievements over the last 5 years, activities taken up and outcome of the previous scheme implemented for the period 70-22-20 and the components of proposal outlay to the implemented for the period 26. The Deputy Secretary Chairman of T-Board made the brief presentation on the EFC proposal of T-Board for the year 2022. He presented an overview of tea sector and highlighted the achievements of MTF scheme implemented for the year 22. India being the second largest producer and fourth largest export tea provides employment to 1.60 million workers, the sector under women. In the year 22 to COVID restriction, though the tea production was lower by around 10%, the average action price of tea increased by 32. He briefed about the following 5 major components of EFC proposal 2021. And it's a pending liability. He said pending liability is 294.98 crores. Now, my lord, can you see the next one, 37, Roman 4. Last, Additional Secretary Department Examiner made the following observation. A liability of 298 KD T-Board seems to be quite high. Further, based on the average of rupees 65 crores of establishment, that cause the total requirement are not more than rupees 350 crores, while the proposal is made for 450 crores, which seems to be over projected. The establishment expenditure of T-Board is one of the higher side, and they are suggested to make themselves financial self-reliant. Now, coming 5.3, it is also informed that the international sector is a highly sensitive and labor-intensive sector which provides a livelihood to large number of population. ST communities, tea plantations are located in far-flung and sensitive area of Assam and West Bengal, where no other gainful employment opportunity is available. As the plantations are located in ecological sensitive areas, where indiscriminate farm practices are the threat to the environment, continuation of research and extension activities along with better management practices are required for sustainable development. Keeping in view the above, exit from the schemes would not be possible. Now, my lord, comes 6 deputy chairman views regarding 3 minor Roman. In addition to deputy chairman, report provides following clarification. I just read it. In this establishment expenditure, it was explained that the average expenditure during MTF on the establishment cost comprising of 2 principal budget heads, salary and pension and other establishment expenditure is rupees 70 crores. He informed that the expenditure has been calculated scientifically taking into consideration Indian DA. As regards the issue of the tea price, and the third is the as regards the use of pending liability, the committee was informed that liabilities are due to shortage of funds to the extent of 55% of the approved plan, outlined 12 plans and 29 during the MTF period. Further, the scheme guidelines in certain activities like replantation, rejuvenation are such that activity proposed in a particular year get matured for subsidy payment only 3 to 7 years. This is very, they have taken no, it expired. They themselves said, I made the application, it matured, subsidy payment only after 3 to 7 years, and therefore the cases spill over from one plan to another. So their point is that since it expired, so you are not entitled to. Here, they have to the object. So replantation, rejuvenation. The deputy chairman has considered it. He further informed that such activities in the big tea orders have been discontinued in the present proposal. The focus of the scheme is to small wards. Can you page 40 plus 10? After the detailed deliberation of proposal, expenditure fund finance committee approved the continuation of the scheme of T-board. Details are under. The scheme was approved, the reduced outlay of 967 crores to bring the outlay in conformity with the limit of 55.5 times for expenditure for 1920. The expenditure incurred at T-board during 1920 rupees 175 crores.
Continue, no issue.
No, you should come back.
You want to leave?
I just take my
All right.
by this I prepared myself.
So, Mr. Roy, another day.
No, today. I'll continue. Yeah.
He wants a break.
Tea break, my
But
lord.
before my ladyship rises, my lord,
Mr. Bhattacharya, 1 minute, please. We haven't finished.
Lord, in PB, one habeas corpus is fixed in second half. So maybe.
Let him
230 or
continue
3
because he will continue for some time. You finish up that matter and then come. And Mr. Mazumdar will be there online, no issues.
So, my lord, Mr.
House
Singhania
by
will
law.
be there. I may not be.
He was in Sikkim.
Let's
They
say
did
when-
not turn up of Siliguri.
Let's say when the matter
Home
is
Ministry
settled,
restricted him.
allow us to attend the deal. When the matter is.
Yes, Mr. Ray will take some time. And there are so many judgments I see. So
3
here,
days, earlier 2 days, 3 hours.
so
Now,
today the whole day he'll continue.
whole day, this matter is continue next week also.
Huh?
He said.
3 days,
I'll
3
finish
days
it.
minimum.
Finish
That
it up.
is single
No,
3
he's-
days, then we 2 days.
Because
Then we 2 days, Your Lord.
the judgment will be delivered as long as I am here. I'll not carry any baggage to the principal bench. I'll finish up.
But
There are
you know,
so many matters.
I'm also going by this changing your lawship. Next day,
Yes.
hoping there are 2 matters there.
Yes. So I'll finish
I'll
everything over here.
I'll come back again. Yes.
my lord, before my lady rises, my lord, item number 47, my lord, I was appearing, my lord, has passed an order directing exchange of affidavits. My lord, may kindly, my lord, my junior had prayed for an accommodation. My lord, may kindly take it up on any day, my lord. Haste me at least, my lord. Thereafter, if my lord so pleases, my lord passes that order, my lord.
Next day.
My lord, may
subject to Mr. Ray's. If he says, then released.
আমি কত আমি জানি না 3:30টায় বেরিয়ে আসবে
No, but then I will continue. I'll not leave Mr. Singhania.
The habeas corpus is.
Yes, yes.
That's
But thereafter, the matter will go on till it is over.
it.
So that the judgment can be delivered. There is no other reason. You all may leave. Yes.
My lord, why I've taken the time, I just can't confess. In this petition, there's one parliamentary report is not there. So I brought it from Calcutta. So if you can allow me, I'll give the supplementary tomorrow, but I just place it. This is a parliamentary. Oh, damn it, this is a this can you 3.5. The Parliamentary Affairs Committee has dealt with this matter. 3.5. Just place it.
3.5.
Yes.
Achha.
3.5 is not there. Just place. The committee is deeply concerned to note the travails of the tea growers and estates in receiving their outstanding dues for undertaking bona fide tea development activities. The committee observes that the administrative decision to accord no objection certificate for conducting development activities leads to huge investment and expenditures by the tea growers estates, which they expect to receive in the form of subsidies. However, the recent decision of the department to deny and grant a pending subsidies on not receiving a sanction letter by TBF even after the conclusion of development activities indicates non-compliance and ambiguous in decision making to clear the dues. The committee recommends that the permit to undertake development activities in form of NOC is an assurance to the tea growers, which should be a basis for reimbursement to tea growers and estates. It recommends that department should earnestly review its decision in order to settle the outstanding subsidies of beneficiaries who had been accorded as NOC for completion of the concerned activities. So the Parliamentary Affairs Committee also said that, my lord, they have completed their work. They have altered their position, but they have not given. This is other. I'll give the entire, my lord. This is a report. Now, my lord. Now I just sum up it. I give the, you want to be judgment?
The judgments are here.
I've
Is this a separate one?
I don't know. Maybe send me not. Your lordship has.
There are quite a few judgments over here.
Huh?
Regular citation, I go with the judgment or the
No, I've given it.
You place it.
Yeah.
In case I find something new, then I'll take
these are all
it.
other judgments. That will help. Something. My first submission is that, my lord.
Yes.
If you kindly come to back page 43 and 44 for a moment. (42), 43, and 44. 3 pages
Of the
writ petition.
Of the writ petition. Yes.
My first submission is that.
No, this I have followed. Now you will develop your argument on the basis of the judgments. You can rely upon those judgments.
Your Lordship, kindly. This is the 1992 supplementary one is before Lordship. Yes. And 1992 supplementary one is the case 21. Well, I just place para 21st. This is 1992 supplementary one is the 21. Huh? So did it put it my there are 20. If you Lordship at page at running page 9, my lord.
Running page 9, yes. Yes.
There are 20 in the middle, my lord.
Hmm.
The court said that the intention of the legislature was to grant exemption only upon the satisfaction of substantive conditions of the provisions. The condition in the proviso was held to be a substance embodying consideration of policy. See, Narashamurthy would say that position in the present case was not defined. He says that notification was statutory in character and the condition as the prior permission for adjustment stipulated therein must also be held to be statutory. Such a condition must, says counsel, equated with the requirement of production of declaration of Kedarnath case, and thus understood the same consequence should ensure non-compliance. She Narashamurthy says that there's no way out of this situation and adjustment was permissible. Whatever be the other remedies of the applicant. Now, madam, there is a fallacy in the emphasis of this argument. The consequence which the Narashamurthy suggests should flow from non-compliance would indeed be the result of the condition. Condition was suggestive one and one fundamental of the policy underlying the exemption. Its stringency and mandatory nature must be justified by the purport intended itself. The mere fact is that statute does not matter on the way or other. Now, madam, there are conditions and conditions. Some may be substantive, mandatory, and based on considerations of policy. Some others may merely belong to the area of procedure. It will be erroneous to attach equal importance to the non-observation of all conditions, irrespective of the purposes they were intended to serve. So there are two types of conditions. Now, I'm paragraph 22. Third line. A distinction between the provisions of the statute, which are of substantive character and are built in with certain specific objectives of policy on the other hand, and those which are merely procedural and technical in their nature on the other must be kept clearly distinguished. What we have here is a pure technicality. But still the notification leaves no discretion to the Deputy Commissioner to refuse the permission. The conditions are satisfied. The word are that he will grant. There is no dispute that appellant had satisfied those conditions. Yet the permission was withheld, not for any valid and substantial reason, but owing to certain extraneous things concerning some interdepartmental issues. Appellant had nothing to do with those issues. Appellant is now told, we are sorry, we should have given you the permission, but now that the period is over, nothing can be done. The answer to this is the words of Lord Dennis. Now I know that the public authority cannot be stopped from doing its public duty, but I do not think it can be stopped from relying on a technicality, and this is a technicality. Now you also can come to paragraph 21. It appears to us that the view taken of the matter by the High Court does not acknowledge the essential distinction between what was matter of form, what was of one of substance. There is no other distinguishing circumstances which would justify the refusal of the permission. Appellant did not have prior permission because it was withheld by the revenue without any justification. The High Court took the view that after the period to which the adjustment related had expired, no permission could be at all granted. A permission of this nature was a technical requirement and could be issued, making it operative for the time it was applied for. Well, we therefore allow the appeal settlement and relevant. We issue this direction in view of the admitted position that apart from the technical objection, the periods to which the application related had since expired, there is no other impediment for the grant of permission. And sorry, but before that, I should show one thing. This kind of new scheme which is excluded. I just place it, then I should come. Well, you also kindly come to, sorry, madam, there's 364 of the writ petition.
Yes.
This is a new scheme has come into force, my lord, for 2021. Relevant case number 396. Certain activities, clause 1.15. Certain activities for big growers and small growers which are approved earlier schemes have been discontinued and not included as eligible activities under instant scheme. However, for these activities, which no fresh application will be entertained, financial assistance would be considered under the instant scheme only for those cases for which formal sanction order has been issued. So they have excluded or deprived us since we have completed work. This is from the records. They have not given the benefits because of their fund crunch. Now, in the new scheme, they have said all the pending cases, those have been discarded. 7 except formal sanction order has been issued. This is my Article 14 violates. I just come. This is the cause of action comes from here, my lord. I should. So, my lord, first judgment which I placed before lordship, the Supreme Court says that some conditions are substantial, some conditions are procedural. My humble submission is that NOC, my lord, making of the application, my point is that scheme says that first fulfillment of the eligibility criteria. Next, my lord, issuance of no objection certificate. Third one, satisfactory post-operative inspection report. These are all substantive conditions. If it is fulfilled and satisfied as per the report, then issuance of the sanction letter and disbursement is a procedural one. This is my first submission. In the present case, I fulfill all eligible conditions. They have made a active report, their inquiry. They have given the NOC. I have completed work. They have the report. Only they have not issued the sanction letter. Although in this scheme, there is no sanction, particular sanction letter is not required. So they have taken their case in the evidence opposition, my lord. They say, since the scheme has been expired, you are not entitled to get the benefit. My first, this Supreme Court that says, it should say that when he applied, if he applied within the scheme, to the Peninsula scheme, if he complied with all the substantive conditions, this part is a procedural. This is my first submission. Now, my lord, I'll place the next judgment. This is, although Madhya Pradesh High Court judgment. That are similar to the case we have. The view taken by National High Court is that similar subsidies sanctioned by the state level committee. There neither any public nor is there any eligibility in the application appeal unique to state subsidies. According to the National High Court, the filing of application transfer confer right on the application applicant for subsidy. Any right either to speak on the principles of constitution. It is great or university to agree with you. In our opinion, there is definitely promise held out by the respondent by declaring the scheme that the entrepreneur who will use the ability and qualification under the scheme will be given subsidy. The promise does not come being on sanction or subsidy by the state level body. Sanction of the subsidy of the due processing that is procedural, not substantial part of the scheme. Once the ability of all kinds of subsidy is acquired, the right to sanction also is acquired. The state level committee delays or denies sanction, the applicant has a right to seek judicial review of such a decision on the ground that arbitrary or discriminatory. Moreover, the matter High Court seems to have missed the consequence of view taken by it in the ground of something made dependent on state level committee. Extra result, data mentioned by the state level committee, extra result will follow. As already pointed out, if two applicants similarly apply on the same day, the application of one is processed first, and receive sanction before the expiry of the scheme. The other application is not processed at first, and before it is sanctioned, the scheme expired. The latter application appears to suffer for no follows part. Therefore, find ourselves unable to follow the decision of National High Court. For the above reasons, it allows this division and neither respondents to decide applicant for grant of subsidy, file the petition on merits on the basis of qualification given the expiry of the scheme. My submission is that I have acquired the right, not only the NOC, the assurance. I agree to my work. I acquired my right. So they can't say that because of expiry of the scheme, I am not entitled to get the right. Because I've already acquired that I acquired. My next point of argument is that I just go one thing. One sentence.
Yes.
The above object, the above component primarily comprises extremely subsidy financial incentive into the greater activity carried out by different stakeholders for improving the production, productivity, quality of the India and promotion of India key international market and development. The object is that if I execute what? So this is object to extend the benefit for development by activity. So this is the object. Object of that they will not give it. My object, basic object is that according to the scheme, I have to execute, I have to promote the activity. That I have done. Now you also can see my next argument is that NOC, according to just assurance or problem. I'm not going by the, it gives me right. On this is the promise. I have executed my, I altered my position. And this is what the report said, that huge amount are here. But they have withdrawn, and this is of the old letter. They say they have given it for the township fund. I have been submission, non-grant of subsidy or including subsidy on the ground of township fund. Yes. The from their own, I place in my 5961, and these are their own document, there's a sufficient fund. They can't say that, no, fund, there is no fund, so it could not give you, or any very specific. They kind of, this is not that case, that even the provide a scheme, there is a public. That is, they can't say there's a very specific policy change. Suppose there should be no figure. It was really actually matter in our Supreme High Court, but that all the cigarette industries. Provided a subsidy. Subsidy that has been given. At the end of the job. At the Supreme Court said yes, can be, because scaling needs to help. It is against the public policy. So the department has the right to decide on this point. Here there is no such case. They said, they only said, no, fund is not there. There's no fund. If they have said no, if they provide the subsidy to the public policy, then they may have. Secondly, they have not said there's any very specific policy change of this. So my note on this. Here, they have taken it, here, in the area of around 13, they have around 30. It's 13 in the operation. What is that case they try to make out? And in the meanwhile, further from me.
Yes.
And further submit that as per the clause P1G of the scheme, the energy issued by the appeal shall not be binding on the board. The application was subsequently found to be eligible for subsidy to other issues. Despite the board writing. The resolution submitted as per clause P1 of the scheme, the committee board is binding only after issue the approval of national commission. And the report covered. Committee of the report covered is visible. I say that apart on individual putting clause stated that individual putting has been completed by 31st March on the financial year for which application has been submitted. Including in the funding has completed by the next financial year. Apart from the in business funding clause, it says that application has been completed by 31st March of the financial year for the application has been submitted. This is the file here is inspection code which is to reflect that the petitioner based on this everything is goes on anything was issued on 10 2015 and inspection arranged by the guardian on 29 January 2021. These are given and the guardian arranged inspection on in addition it is said that no committee case subsidy was made that is student supervision. There is no violation of information and the same has been followed. No legal right or sexual right or has been increased at any point of time. And the students are reasonable, legal, and not unreasonable. Question of committee of the respondent for decision, other things does not arise. So the respondent never found to say the case. But I think more of that I applied right now. Initially was given. I executed the work, I implemented it with time. 3 to 7 years. And they made the inspection. If they said, the inspection is not binding on them. So the inspection was made after expenditure of state, but it cannot be case. So, what said, when he applied for, your officer conducted, only to see whether we consider work or not in time. The report of the report certified that, confirmed that yes, we executed work in terms of the stream within the time. So this is my answer. Now, my lord, in this, here, my lord.
Inspection was conducted by the T board.
Keyboard officers.
Very good.
There we go. So this is our scheme, say, that we go.
Alright.
Can you see? I don't want to. Suppose they say, that I will conduct a work after expiry time. Without taking on their thing. But if that would be so, if that takes my right, so why they have the if next thing, those pending cases are set. If there's a no, if there's a, suppose the second scheme, Indian scheme, there's a proviso that who are of an obligation, they execute work after that, they would not be entitled. They say no, all the pending claims, and now 11 and 12, those are said under the scheme. And they have never said that your pay was rejected on the ground that you have not completed the work in time, and the inspection report according to your work is not satisfactory. In this context, I place three judgments. The complaint comes to 2010. Yes, my position is that my lord, they gave me assurance. I alter my position.
Promissory estoppel.
And the time comes, I know, there was 270. And I know 35 is the has given. In 74, I was very bad. Your opinion that it's a law about the permission of Sabha thinking that in order to invoke the access of this, is that the party must make an unequivocal promise or dispensation by word or conduct of the representative was intended to create some position, but ethical legal relationship to arise in the future. A clear foundation has been laid. The division is supporting government. It has been shown that party invoking the doctrine has altered its position, designed on the government. This is possible for the government to dispel from its promise when public interest is evident. The government was required to carry out the promise. The court would not apply the doctrine to the staff. On next paragraph 61. At page 1941. In addition to Mr. Secretary, one is senior counsel, relied on a number of other decisions which he may notice. The NP Makur, having court stated that in order to invoke the doctrine of commutation, clear, sound, and positive foundation must be made in the petition. If the party invokes the doctrine, all extension without material would not be sufficient. And here, in the intercase, the transparent for the they can be assured by order regulation. Now, I will come to 79. Here, here also I would say, submission that the decision dated has been taken due to the change in the national government. It was not justified by the government on the basis of the one year of future nature, financial nature. It is stated law as noted by Bhagavad Muslim that government can fail to be exempt from the liability to carry out the public of some indefinite and undisclosed ground of necessity or this. The government is required to pay to the court the entire material on account of which claims to be exempt from liability. Therefore, it will be for the court to decide whether these facts and circumstances are such as to render it inequitable to enforce the liability against the wrong. May claim of change of policy, but it's sufficient to exonerate the government from liability. Mere claim of change of policy is not be sufficient to exonerate the government from liability. It is only when the court is satisfied that court would try to enforce upon the government, how the burden would be upon the government to show it would be inequitable to hold the government bound by the promise. The court would insist on a high standard of proof in the discharge of this burden. Here, this appears to say, I should get it. Next, panel 8. The four digits, depending support of the digits are fairly arbitrary, so no longer obtain the appearance, not to issue the notification on the ground that policy has that. The second reason that the exemption should not be granted to company and no notice has been issued under short term cannot be accepted. Appearance cannot be until to take advantage of the own wrong. They were to keep the covered full time. They are wrong. The third reason given is that state level committee, inquiry committee, has not approved the application package. It clearly is against the record which has been exerting by us in the earlier part of the justice. Not only was the exemption recommended by the committee and the industrial policy, entity taxpayers are given the notification will be issued within a very short period. The fourth visit will clear to the revenue on the chief minister conference. It will equally take 10 years. My submission is that they have take one branch. They can't take this point. It's a very extreme. They say no, the new scheme for the small board. That cannot be taken into our system. And next chapter is my lord. The 80, 12, 85. So the chapter says 60. Yes, 79 is the revenue. So the 80, 55. It's so fast. That's the 77. As to be being from the above below enunciation, the property of the is giving actually clear, objective, non-arbitrary, transparent, and non-discriminatory. Theoretically, many you have got in Assam, they got. In Bengal, they are get because of Japan. Let's see. A decision based in such an authority, which is a concomitant of its power, is coupled with the duty and can never be unregulated or unbridled. Any decision or action contrary to these concerned steps would be at the pain of individual thereof. The state and its be a public authority, either as an individual or a collective, has essentially abide by this inalienable or non-negotiable prescription and cannot act in breach of the law, report the public and on exterior consideration. In exercise of uncontrolled discretion power cannot resort to any act instigated, further, investigate any public property by way of state charges or conduct, state up to clarity and constitutional the rule of law to form the base of the constitutional order. Next cabinet is 2023 634. And Carbon dialogue, there is 2. Regular dialogue 49, 100, 107. Problem differentiation in the above term. It is manifestly unclear. I believe in describe in the unit in the state of the in the state government is as a matter of that issues and technical division. The 9 by now by 3 so prospective depends on 8 challenge effective. Negative the nature of the response is in the which or then out in the interest of the job. Absolutely no substitute to hearing or legal of police or public interest offered before the High Court or before the court or delay issuing a notice. The proceedings are completely silent, the review of on the part of the government and offer no justification for making their exemption constitutionally contrary to the terms of the decision held out in the interest of the job. This is one thing for the state. Assert that this person has no vested right, but quite another for the state to assert that is not duty bound to store its results for not giving effect to exemption notification, which is a pure that was efficiently interest of the secure. Both the accountability of the state, program of the issue which is understood in terms of policy document, limited against accepting such a notion of state power. The state must discard colonial notion that is a sovereign handing its doors as its will. Its policies give rise to legitimate expectations. The state will act according to what it puts forth in the public design. In all actions, the state is bound to act fairly in a transparent manner. This is an elementary requirement of guarantee against arbitrary state action which Article 14 of the Constitution adopts a deprivation of the entitlement of private citizens. The private interest must be proportional to a requirement of the public interest. The concept of state power has been recognized by the court the concept rights of decision and investigation that the government and the department in administering the structure of the country expect to honor the statement of policy or intention and treat the citizens with full possible consideration without any act of abuse of discretion. The policy statement cannot be clearly unfairly applied blessing. Unfairness is the form of undoing is acting to violation of natural justice. Therefore, it is clear that state has made the conditions to the respondent similar to the industry policy. The reason the state likes a registered existence of their behalf that they would be offered citizen debate with the next 5 years or due to the failure of the constitution, the single time on the grounds of the existence only prospectively the expectation and trust the state would violate. The state has offered no justification for the delay in issuing the notification or provided exist but being in public interest. The whole that of the court of action, the state is actually and my case is that my lord, I completed war. They are not getting. They know it is rejected. It kept it pending for a long time. And that was quite the next thing. All of a sudden they say, no, you will not get it, you will sign. All of signs is not there, you are excluded. Now, my lord, judgment, it takes place on the 19th. My lord, whether it can be for the report or not. Here I say, clause 1.6 means the current scheme is comprehensive and value article 14. Our High Court is the judgment, my lord, it is paragraph 21. This form will be thank you, Lord. The single activity tribunal certainly competent express intuition in relation to recruitment and matters concerning recruitment for a certain sort of environment. But the decision is this can be granted by this court and article of opinion. We don't need to be against lack of prevailing of certificate, the tribunal that has exactly the power to enter a list of this sort that has been last as a public service. But in the case of question of declaration of security on the part deciding to find out the reason of the institution participation of the applicant case, this for the power to grant security, you see the court is satisfied about the sustainability. So here I ask for, they can say that this is my consequence of the review. I say, after 1.15 of a new scheme is arbitrary, that should not be in consideration. So they can say, this court can decide as a arbitrary or without going to the question of otherwise. But this is my submission. I see. They are in the operation. They are right up on judgment. Judgment. The ultimate side of accept the of their operation.
Yes.
I think judgment. They are right on the judgment. They are annexed. But you see, case 67 first paragraph. So this is made about, I hope that the picture answer is able to establish where he is entitled to compensation being the subject. In the application of beyond a scheme of them fund and on his sole ground that he cannot show his entitlement to the subsidy. But the student said that application subsidy made by the was accepted by the keyboard. It was not within the knowledge the lifetime of sanction under the aspect. The petitioner not really challenge the statement made on both by the response. I also do not find anything to deliver the statement on oath and thereby I hope that no way the petitioner can establish that the intention to the constitution. Whatever the interpretation of keyboard, no action was given to the petitioner. The petitioner while submitting the application for subsidy on the state, given a very specific letter that he did another all the terms and conditions scheme, relating to abide with all terms and conditions. Also, such terms for relating to no official certificate. And this is new about this. So the still knew that there is no assurance or a condition on the part of the keyboard giving him the subsidy. For this is as I hold that it does not have any case for getting subsidy. And here the case is that they got auto no objection. On the basis of that, they applied for the subsidy. So this judgment I have distinguished that my case is not that I applied on the I applied to substitute on this law objection. My case is different. My case is that I got a law objection, then I executed the work, there is a post inspection report, they immediately for charge of one, now they are these judgment ratio less than the judgment of facts are different in the context of my country.
There is one more judgment you have annexed in your compilation.
That declared issued, my lord, 2019 is online Calcutta, declared about this judgment. Can you come to paragraph 21 for a moment? Page 129. Page 129, running page 129.
129 of your compilation.
Yes.
129.
Judgment of our High Court,
Relied upon
this judgment. So I have annexed.
All right, all right. These are your submissions.
And look, I have one short notes to argument and may 2 or 3 points I have not taken here, but most of us have taken. Parliament Affairs report I have not taken to my note, my lord, so that time it was. But
All these judgments you handed over in the last location.
One by answer.
Yes, now compilation is better. It is good. You can take.
Maybe. And issue.
Yes. Why Monday? I said I am going to continue.
This matter.
Huh?
Yes,
Yes, DSG is here.
No.
Where is he?
In the house.
No, but then he's online.
Online. They returned back from 11, second item from 11:30. Yes, sir. So they will do it. Monday. Second half.
Monday, second
On
of
the,
so
on
many
the last
motions.
occasion, I concluded Friday they did not turn up.
Yes.
ওটা তো শুক্রবার আমরা রেডি ছিলাম ওটাই আমরা রেডি দ্যাটস ইট DSJ leave this matter. I'm ready for written notes of arguments also.
You are ready? Written notes of argument ready?
Earlier we have ready.
Give one.
I will not copy it today. Monday I will provide you. I'll provide it Monday.
See, I still have time.
So I'm DSJ leave this matter.
This is the reason I don't like, or other courts also don't like taking up hearing matters.
But we are in a problem, my lord.
I understand. If
For this matter, basically I got other matters. This is I have come, but because all decadence, but some matters in Madras High Court, some in the Assam High Court, all lawyers are ringing me. Mr. You have done it here.
All over India is pending, 45.
And
in our High Court is more or less 15 or 16 matters.
And no decision taken in any of the matters.
Matter is 2022 and 23.
Before your lordship.
Before your lordship. If those matters is decided, then other matters automatically on the
I
same
see
line.
only one.
Yes, only one, and item 67 is also there, your lordship.
No, this is
And in 67,
685.
We are not going to mix it up. It is only this ringtone 22
matter.
matter.
That is a different. This is different.
Basically,
I'll place it 600. Not this
Legal
doctor.
document.
Don't.
Submission made on behalf of the now, learned senior counsel representing the petitioner commences and concludes arguments. on the prayer of the learned advocate for the Union of India.
And keyboard also.
Keyboard, sir. You are representing keyboard.
Both.
And at a respondent for the
All the rest.
respondent. List for hearing on Monday, 28th Tarikh. I do not know when the court will find time with so many motions in the list on Monday. I kept it on Friday only for this purpose so that the weekend I can utilize for preparing the judgment. This is not fair.
Can you give me 3 p.m. then it will be.
No, I am not
Sorry,
mentioning time
I should know.
because I want to
And I
finish up as much of motions as
No, but
possible.
I know your lordship.
I am running through the list every day.
Yes, absolutely. I know my lord this.
In Monday also, mentioned.
More than 100 matters or 150 matters have been mentioned.
I mentioned 4 matters. First day I mentioned.
We are getting the
Again-
smell of the earlier days, you know.
Yesterday I mentioned
Justice Umesh Banerjee, 90 matter.
at least 4.
But you also joined the profession then. Just Banerjee.
I have
My-
appeared before Justice
my-
Banerjee in
my
many
first-
matters.
My first appearance with Justice Banerjee, he asked me, "What's your name, please?" That I just came out, me right chambers.
Is anybody there for the other matters? One of your matters, Mr. Dey, has been disposed of. Your name will be recorded. Similar matter, factor 2.
Factor 2.
That has been,
57.
yes, your name has been recorded. খুঁজে পেয়েছেন? দিয়ে দিন, ও তো আছে এখানে। হ্যাঁ।
Mr. Rahman has informed me.
Yes, I told him to
Yes,
inform you.
I have been informed by Mr.
Yes.
My lord, an item number 49, Mr. Bhattacharya is appearing. My lord, can it be taken up Tuesday? My lord, he is some personal difficulty on Monday. Item number
ওটা কি
49.
সোমবার করা আছে?
49.
সোমবার করা আছে?
Pass over, my lord. Regarding that trade license petrol.
Oh, where is Mr. Ghosh?
My lord, Petrol.
Huh? It is for him that the matter was passed over.
Yes, my lord. My lord, I shall inform you.
Very well, Tuesday করে দিন ওটা
Tuesday.
তাহলে।
I'm grateful, my lord.
Any other matter?
But we are waiting for our bar association matter to be heard.
Yes.
And
Is the
today-
other side there?
Today is the second anniversary of the first hearing of in this matter, my lord, before her ladyship, Moshe Bhattacharya, which was ordered on 27th of April, my lord. After that, no order was passed, no effective order was passed.
Yes, is your other side there?
Very much there, my lord.
I have heard the matter has been released. That's why
Yes.
I have asked the Prabal Mukherjee not.
Yes,
Now, my lord,
yes.
my lord,
The
I just,
matter- I have released
Yes,
matters
that's
because I did not know because the respondent will not be there.
my lord, I just put into your lordship notice one thing.
Should not be.
In every, I'm very apprehensive. In every circuit, whenever this matter is listed, this matter is dragged till the last day of the circuit. And then something starts, which is so, one sec,
No.
which is so wide,
Wait.
one sec,
Please wait.
which is so wordy and rambling that it never finishes, my lord. In this way, my lord, for the last 2 years, we are unable to get this matter disposed of. Despite there is a Supreme Court Constitution Bench judgment in Kaushal Kishore versus State of Uttar Pradesh, my lord, which explains every maintainability claim, non-maintainability claim of the respondents, and it is there discussed in the first order 27th April 2023 also, my lord. Despite on every day, my lord, the maintainability is discussed for reasons unknown, my lord. Any day this circuit, any time this circuit, as per the convenience of the respondent. Let this matter be listed and disposed of
It is listed already.
for final hearing and disposal.
It is for final hearing.
But this will go on till I'm stating this, your lordship will see this.
What will the court do by seeing this? If parties are here, the court will hear.
My lord, my petition at the whims and fancies of the respondent is not getting heard, my lord.
Why will it be so?
I am waiting for the last 2 years to submit. Only 10 minutes I need. 5 minutes maintainability, 5 minutes petition.
Hearing on many applications has already been done, but your lordship's coordinate bench has asked for reconciliation. That
Reconciliation
Yes, that
failed.
failed.
That failed because the respondent never came there on, first of all, they made us wait for two hours. Then the secretary did not turn up.
The president
No,
came
no,
and said,
no.
one sec, sir, please.
Record is there. No, no,
Please.
record is there.
Please.
Record is,
Record
don't
is
say
there.
anything beyond the record.
I am,
No.
everything is stated here beyond the record. I'm telling this from the record. I have witnesses to this. We have photographs to this. And then it is said.
Do you
that-
still want reconciliation?
No, I don't want reconciliation. Man,
That means reconciliation failed.
whenever this, there is no scope, my lord.
proposed in the last circuit.
We have letters
Let us go
that
for
we have given. Okay, we are
We have
ready for
tried.
reconciliation, but they are telling us
Send to Siliguri
whatever will
RSS.
happen in the GB, that will stand. My lord, there are few more things, my lord. There is an element of criminal contempt of court, my lord. I have documents annexed and filed. It is, I'm telling this from the record, stating this from the record, my lord. Criminal contempt of court, unconstitutional provision, violation of fundamental rights for the last 2 years is going unnoticed. Can that be a possibility, my lord? I am begging for mercy, my lord. For the very first time I'm doing this, I'm begging for
It's
mercy.
nothing
Let
of
this
that
matter
sort. The
be
matter is
disposed of,
there
my
in the list. If it is
any day,
there.
any day, as per the convenience of the respondent. We will be there from the morning.
See, these are matter of advocates.
Yes.
You are also advocate. The other side is also advocates. Why will the court engage all advocates from the morning? The court sits at 10:30. Whenever the matter is there, it will be called on. Nobody is required to stay here. If you are here, let him start his submission.
My lord, Mr. Prabal Mukherjee appeared on so many occasions in this matter.
He will appear on the next
My lord,
day.
Mr. Bikash Ranjan Bhattacharya also appeared.
No.
Mr. Partho Sarathy Bhattacharya also appeared. So we are not saying that
Maybe.
Bikash Ranjan Bhattacharya is not there, so we will not argue our case.
Well,
We'll argue our case.
Mr. Mukherjee was practically present since 12 noon. Court
Practically
released the
present
matter.
means he was here. He wasn't. He was there online.
Yes, through
Then
online. So
let him remain present online.
Yes, I will request again. But I have already requested Mr. Mukherjee that matter has already been released. All the matters are released. That's why he has been engaged in another matter in the principal bench.
Let him remain engaged. No difficulty. The petitioner presses for hearing. Let him start. You are here. The court time is still there. Tell Mr. Mukherjee to join. It's not that he's gone somewhere else. Let him start.
Then give me some time, my lord, so that I can.
Go. Let him start in the meantime. Dekhi ki file ache. Which item?
Item number 69, 70, 71.
All right, 69 file dekhi.
71 will be make for submission.
What is the relief that you are claiming?
I am claiming that on the basis of the clause 3E, which is an unconstitutional provision, our
Clause 3 of what?
clause 3E of the amended constitution of the Siliguri Bar Association.
Is the bar association a registered association?
It is very.
And in item number 71, I'm petition person.
And 69 petitioner in
I am
person.
petitioner in person.
Open your band. Why the band will be there if you are there in court? Bar association is not registered.
Yes.
Not registered.
No, it's not registered. But they are intent to register, they make some amendment in their constitution.
Now,
in their constitution, they make a 3E clause, which is violated Article 21, 14, and 19(1)(g) of the constitution.
C also.
C also.
But the bar association is recognized by West Bengal Bar Council.
Yes. Let him remain on legs. No difficulty. You are here. Let him start. Yes.
This is going on for the last 2
Let
years.
me understand what it is.
Yes, my lord. So, my lord, on 13th of March 2023, my lord, a clause 3E was inserted in the amended constitution of the Siliguri Bar Association, my lord. It is there in page number 23-24, my lord. Of my petition.
Let me understand one thing. You want You want yourself to be a member of the association?
Absolutely, my lord. I'm the member for the last 16 years, my lord.
You are already,
But my membership was seized as per the new amendment, my lord.
all right, your membership has been seized and that is the reason you filed the writ petition.
Absolutely.
Right? And the Siliguri Bar Association is an unregistered association.
Absolutely.
Right? How is a writ petition maintainable against this body?
Yes. Should I talk about the maintainability first? my lord?
Yes, because that is the issue that has been raised,
Yes, ma'am.
possibly the maintainability.
Absolutely. I mean, my lord, in this Kaushal Kishore versus State of Uttar Pradesh, my lord, the 5 judges bench, the document is already there, filed. Judgment is already there, my lord.
Judgment is here.
Yes, my lord.
In 1094, it is final by.
1094. 1094 টা আছে দেখুন তো 1094 92 Is it here
It is there.
in the spiral binding?
Absolutely.
Yes.
Now, my lord, in page number 31, I have the live law, that is the, in the page number 31, my lord, there is a question framed by the court itself.
Where is the page?
This is a SSC.
SCC page 31. Yes. Yes, which paragraph?
Yes, my lord. The question which was framed by the Honorable Supreme Court, my lord.
Which paragraph? Page 31?
My lord, page 31, it is written, question number 2, paragraph number 46, my lord.
It's not
It is in the page number 24.
My lord, a little difficulty in the page numbering is there, my lord.
All right. So your friend is there to help you. Page number 24. Possibly this is also not telling.
My lord, first line, my lord. Question number 2 ought to really read as follows. Should I find it?
Find it out, please. একটু দিন তো ওটা। Why are you not accepting these advocates as members? Any reason?
Yes.
What is the reason?
So, because they are, in spite of the fact that the resolution is there and the bar association rules are there, that any member of the Siliguri bar association cannot form and cannot be member of another bar association within the Siliguri Municipal Corporation. But in spite of this resolution, they have taken the membership of another bar association, that is the DRTA bar association, that goes against the rules and by rules of the Siliguri bar association.
If I can correctly remember, in Calcutta, there are advocates who are members of the Bar Association, the Bar Library Club, as well as the Incorporated Law Society.
Maybe, but there might not have been any incorporation in their constitution or bylaw.
Exactly. What is the reason that you have incorporated such a
It is going
clause?
on. By the meeting of general body, it has been passed.
Why? Why?
Absolutely incorrect, my lord. False.
No.
Please wait. I'm just trying to understand what
As
is the reason.
Even my lord, when the amendment was brought by the Siliguri bar association, my learned friend.
What is the reason for the amendment? There must be some object. You are restricting.
Siliguri is a very small town, and Siliguri bar association practically wanted to be only bar association in the Siliguri. The RTI bar association has been newly formed. And it has been going on from the Siliguri bar association, the rules of the bar association, that no member of the
Why this restriction try to apprise the court? Why are you coming?
general body.
Aha, there must be some reason. You cannot go on passing all these things. You advocates are matured people. They handle with law. And you are restricting some other advocate to be a member. Why? Small cause court bar association member is a member of the city court bar association, is a member of the metropolitan court bar association. Where is the difficulty? In the same building they are there. Why will you restrict? For what good reason?
The reasons are explained, my lord, in the draft itself.
For that, one another amendment has to be called.
I am not concerned with your amendment. I just want to know the reason. Why are you imposing this restriction? There must be some plausible reason. You want to hold the body to yourself and you do not want somebody else. Why? Why?
So this is the member are 2,000 members in the Siliguri.
Let there be 20,000. It will be better for you. More the membership, more will be the subscription amount. It is for the betterment of the bar. Then why will you restrict?
Even in the DRTA Bar Association, the Siliguri Bar Association has their own association office.
So, my lord,
and in spite of the fact, these DRTA Bar Association, they have formed and bypassing these Siliguri Bar Association.
Why will you stand in the way of somebody else forming an association?
No, we are not supposed to restrict any embargo on for formation of any bar association.
Right.
They may be.
Yes.
Any member.
Leave it upon the members where they will take their membership, whether DRT, whether Siliguri, they can take both also.
In that case, they are not permitted to member of it.
Why? Why? For what good reason? Just tell me this. For what good reason? You are taking a resolution to achieve an object. True. Why will you not permit?
In fact, my learned Payne was the member of the amendment constitution.
Absolutely, my lord.
Yes, no.
I was myself.
In that amendment that was supposed to be made in the Siliguri violation by law by learned Payne.
I am not going by the amendment. I just want to know off the record what is the use of an amendment or what is the use of a law.
Who can like the court and everybody.
So you do not know anything about it. You are the bar association representative.
Why it has been brought, I don't know.
Because that is the main thing. Possibly he will be he or whoever it is. Today it is he. Tomorrow some XYZ can always come and say, see, I am DRT's members. I want to take membership of Siliguri Bar Association. Why will the Siliguri Bar Association restrict it?
But it is not restricted in the tax bar association, my lord, where they actually have an office.
Wait. It may be tax. It may be some other association also. In Calcutta, there is a tax bar association and they are members of the Calcutta High Court Bar Association. Nobody is stopping them. What good reason? Be rational.
Of the Siliguri Bar Association that has been
For the betterment, you take more membership. You will earn money. What is the membership subscription charge of your association now? How much are you charging?
For the new membership, 10,500 and yearly
And every other day there is a new.
Even Calcutta Bar Association,
Absolutely.
yesterday I took information, it is 11,000 around.
My ladyship, in our
No, Calcutta Bar Association. Yes, 10,000, 10,500. Yes. For me, it was a little bit more, but then it is something like that. 10,000 rupees and you are not accepting membership and you want betterment of the bar. Where from will the money come? Huh?
You are the member. You are
Listen, he was a member. There may be new members who will come to you. You will not take them members because they are members of some other association. Out of your mind. What? Be rational. Don't be irrational or do not please do not put in personal vendetta in all these things. This is for the betterment of the bar association. Think rationally. What will be your answer to this? There may be other reasons. I do not know. I am just asking that this is how I have seen it in Calcutta. Why will it be different in Siliguri? It is as simple as this. There is no restriction in any bar association in Calcutta to obtain membership of any other association. Why this restriction?
Knowing fully well that there is a.
I will not go by that. I want to know. I'm not entering into the matter. I have not opened a single paper. I want to know only what is the reason of this restriction.
Should I read out, my lord?
Are you aware
I am
of
aware.
the reason for the restriction?
I was a elected representative then before I got dismembered. Then on my suggestion, my lord, because a 160 years old bar association is not registered, on my suggestion, the registration process was started. And the registration cannot be done without the constitution be put in the format as is required by law. So in the garb of putting the old constitution in the format, my lord, these all things were done. That too in front of me. I was the part of Constitution Amendment Committee also. Now, my lord, what goes out? Anybody who is charged of an offense which involves moral turpitude cannot be a member. One sec, sir, please let me finish. I did not oppose.
Again,
I have opposed every time.
I am not going to the merits. I only want to know what can be the rationale.
I'm just
I am not opening the brief. Yes.
So, my lord, when the registration process started, my lord, which provision goes out that anybody who is charged of an offense or guilty of an offense involving moral turpitude cannot be a member of Siliguri Bar Association. It goes out. What comes in, my lord? Anybody who is a member of any other bar association where Siliguri Bar Association is operational, his membership will be seized. Then an explanation was given, my lord, because most of these political people, they are also the members of the tax bar association. They run the politics there also. So now exception was given. This particular provision does not apply to the tax bar association because Siliguri Bar Association does not have any office in tax bar association, which is absolutely untrue. Now, my lord, to the best of my knowledge, the definition of bar association is it is the extension of the court in whose premises it is situated. For example, Circuit Bench Bar Association is operational in Circuit Bench of Jalpaiguri. Can the Circuit Bench of Jalpaiguri say, okay, we will also operate in Kolkata Principal Bench also? Because we are operational there. That cannot be the possibility. Siliguri Bar Association or Siliguri Court has a jurisdiction over the Siliguri subdivision, barring some of the areas which comes under the Bhaktinagar PS, which is under the Jalpaiguri. Now, my lord, DRT Siliguri has a jurisdiction from Murshidabad, Malda, 4 districts of Sikkim, Uttar Dinajpur, Dakhin Dinajpur, my lord. How come, even if I consider that in one area there can be only one bar association, then also it is not justifying the cause. And any which ways, ma'am, my lord, that if a particular person wants to form an association and be a part of an association, it is his fundamental right, my lord. Now, my lord, in this case, when this association relates to a profession, by not allowing us, by dismembering us, our 16 years of practice and whatever we have made from this 16 years is at stake, my lord.
Why?
My
If
lord,
you are not a member of the association, you can always practice.
I understand, my lord.
Then
I can practice. Excellent.
Oh, I can see he is in robes, he is practicing. Yes.
I can do, my lord.
Yes.
But there are things, I have proofs of that too. There are things like, if I will move before the Siliguri court, then I will not get favorable order. Such information is, I can give this, I can give this. My lord, they call me traitor in front of my clients. They have written this in a public platform. I have taken the screenshot also. I do not want to produce all those things. It will only make things worse. I am on to only one thing, that the constitutionality should be. I do not know how this reply, the affidavit in opposition says that they are not bound by any law whatsoever. To the best of my knowledge, law is above everyone and the constitution is the highest law of the land. So any provision which is made should be in consonance with the constitution, my lord. If it is
the
not, then it is
Calcutta Bar
unconstitutional.
Association is also not registered. Mr. Ray, are you aware? High Court Bar Association is not registered. Not registered.
So be it.
When is it registered?
Now registered.
When? Very recently.
Very recently. In
Very recently, maybe it has. Yes.
Actually, this question of maintainability was discussed in details for 2 days, my lord. And our learned senior Ablesh Roy was also there. And he explained the maintainability. We have given the document, this Kaushal Kishore
Can you
judgment.
please say, Mr. Ray, since you are a senior member, what can be the justification of restricting somebody?
Our Supreme Court said, this is a matter of internal politics.
Yes.
I sorry to say.
No, this I can understand from the very beginning that there is some personal vendetta which is just crippling the writ court with all these matters.
One thing, that I also member of the other bar as well.
Yes.
But only Supreme Court says only they can restrict voting right.
Absolutely.
If others they can't take away my membership. This is a certain law in the Supreme Court. And when I argued this matter, we just
10,000 rupees membership fee. If you restrict somebody, it is the bar association which is at loss. Nobody.
It's a collective function, my lord.
And see, today he is here. The association may have some personal grievance against Mr. X. Tomorrow, Mr. Y will not get a membership. It is the association which will lose, and Mr. Y will go on practicing everywhere.
Yes.
Nobody can stop him.
This is again
Today, he may come up and say that, see, such and such court is not giving me favorable orders. There may be many who are not members. Even in Calcutta High Court, there are so many advocates who are not members and practicing fluently, practicing flourishingly.
Yes.
No difficulty. Then why this?
If your lordship is actually asking the main reason behind that, it is the main reason. I am very sorry to.
I do not want the reason. I will not enter into any personal
irrationality or arbitrariness. My submission is that, my lord, they have a right to take my voting right. They can't take away my membership because I'm a advocate. I have a right to get the membership. They can't reject it for any reasons. But since I'm a member of the other bar, this is absolutely irrational.
This should not be. Without looking at the papers, this is my first opinion about it. When everybody is wearing robes, so there has to be some bonding between each and everyone. You cannot fight with everybody. Every day you go and see his face. He also sees yours. Right?
Somebody, maybe the juniors of the other.
Yes.
Happened something.
From the same chamber.
Yes.
Not unnatural. So why this enmity?
Your lordship, sorry, can you appoint one senior lawyer who should arbitrate this matter and decide?
I will appoint you if you say.
My lord,
We have no objection. We have no objection.
They will object.
No.
Because Mr. Ray was appearing for
they
them.
will never allow anybody to perform, my lord.
Still, we have a lot of respect for Mr. Roy. Court can appoint him as well.
Do I? If you say, I will appoint Mr. Ray
We have no objection.
to arbiter, to negotiate, and to come up with a solution. Because he has got
time-bound manner, my lord. Because what I have experienced.
Time imposed upon Mr. Ray. Sorry.
No, my lord.
No, they are
not
scared of lingering of the matter.
Absolutely, my lord.
I understand. I understand.
My lord knows if I'll take it, I'll do it.
Yes.
What happens, my lord? Every time the bar council says that relegate the matter for mediation to us, but only when the court is in session and the matter is there. During the time when the matter is not before the court, I have personally called the bar council that kindly mediate the matter when the matter is not before the court. Why it is always when the matter is before the court you make this submission?
My lord knows the experience of the bar council.
Bar council cannot.
I know. And is there anybody member of the bar council over here also? In
Mr.
Arun Sarkar.
No, my lord, better. No, you better. Yes.
There is a small difficulty actually, I would say, because Mr.
Piyush Bar Council representative also there.
In this matter for the petitioners on the first hearing. Rest, it is the
question of mentality I have overcome.
Absolutely.
Representative of Bar Council is already online.
So there is a right to.
Oh, Mr. Mr. Chaturvedi is there, but he is from Calcutta, so for him arbitering will be difficult.
We are ready to accept.
Today, you will accept because he
Yes,
was
yes, yes.
leading you.
Yes.
Tomorrow, but the Siliguri Bar Association will accuse Mr. Ray. And I do not want Mr. Ray to fall in any type of thing. Have you followed? So if somebody with Mr. Ray is there, then it will be better.
There is 4 member from North Bengal,
Hmm.
Bar Council member.
Hmm.
The 4 member can be also part of this committee.
More the heads, more difficult.
Nanamoni, Nanamoni.
অতি সন্ন্যাসীতে গাজন নষ্ট।
As my leadership director, there is a two member. Yes, Mr. Chaturvedi.
In that case, I can appoint Mr. Ray, provided you give consent and a record, so that next time you don't go and challenge and accuse Mr. Ray for entering into all these things.
Everybody have.
If it is on consent, then it can be done.
Do my lord,
Lord, I appear on behalf of the Bar Council of West Bengal.
Mr. Chaturvedi,
My
in the
lord.
midst of the
I'm sorry, my
argument,
lord, I am a
or
little
rather
delayed.
submission, doesn't matter. I'm just telling you that
My lord.
Mr. Ray is over here, Mr. Amolesh
My
Ray, right?
My lord.
Now the parties, they have consented to get Mr. Ray appointed as an arbiter so that he can go into some type of negotiation to find out a solution to the problem that has been created.
Yes. No difficulty. No difficulty.
Right. And since Mr. Ray is from here, senior member, and I am doing it on consent because Mr. Ray appeared for the petitioner, so that the Siliguri Bar Association does not raise a point later on that he is favoring the petitioners or something of that sort. Mr. Ray should not be put into any type of accusation.
Yes.
Right.
On the last occasion when this matter was
time.
taken up,
Now he is a designated.
on the last occasion when this matter was taken up, Lord,
Yes.
I proposed before the coordinate bench that if required, Lord, the parties can approach the Bar Council of West Bengal, come up with grievances if it can be resolved in Calcutta. But since Mr. Ray is there and my lord is my lord of the view that Mr. Ray can, my lord, use his good office to resolve this issue, my lord, I have no difficulty in it. If required at a later stage, my lord can definitely relegate it to the Bar Council of West Bengal. But for
That
the
is a
moment,
later
Mr. Ray,
stage. Right now, Bar Council has no function also. It is
My lord.
between the Bar Association and one of its members who have been expelled or his membership seized, something of this sort. So Bar Council as such is no way involved.
My lord.
Right.
My lord.
In the meantime, that notice of dismembering. Maybe
Wait.
Maybe state
This notice was passed long back.
2 years.
2 years. Now, if it is state, you again go back to the association and create problems. Mr. Ray is here. Wait for some time. Wait for some time. Let good minds come together and let a solution be found to this problem. And I'm sure Mr. Ray will be able to find out a solution. Right? So please wait. Upon hearing the submission made on behalf of both the parties, it appears that there is a possibility of an amicable solution.
That has failed earlier.
Stop. Mr. Amolesh Kumar Ray, learned senior counsel, is present in court. Stop. By consent of the learned advocates representing the consent of the petitioners appearing in person, comma, learned advocate representing the Siliguri Bar Association and the learned advocate representing the Bar Council of West Bengal, comma, the court requests Mr. Amolesh Kumar Ray to act as an arbitrator and to find out a solution to the problem that has been created. So, the parties are directed to render all cooperation to Mr. Ray. Stop. When do I place it in the list? List the matter in the month of June 2025. It is expected the problem will be solved with the able assistance and guidance of Mr. Ray. Anything more you want to add?
I give a report.
Yes.
Well,
Mr.
we have-
Ray.
we have a circuit in May also.
Wait, give some time. The animosity will take some time to be reduced.
It is actually, my lord, the animosity is not from me still till date, but it is actually me who is suffering the most, my lord, because
Whatever it is.
Yes,
ঠিক আছে? Mr. Ray is requested to file a report on the next date.
Mr. Ray should be given some time and some hospitality.
Definitely.
It goes without saying. I am not mentioning it in the order, but this goes without saying.
My lord,
I'm grateful to my lord, deeply obliged.
question which your lordship wanted me to read out on the answer, my lord.
No.
5 judges, 1.
Next. Do not go. If
question
matters can be solved without looking into the papers, this is the best thing for the advocates. It is only for the advocates. Otherwise, no.
I take my lord's kind leave.
Sure. It's already 3:30, Mr. Chaturvedi.
My lord.
Friday evening. Enjoy.
Yes, I'm grateful, deeply obliged.
You're going back
I come back in my.
again?
Just what is some opinion?